Call for it.
Sir, my lord, in this.
This we have already heard.
Time and again, my lord, they are making this sort of.
Let the matter rich. Let the matter rich, we'll see.
Correct.
And whatever you have filed, you call for it. Yes, Mr. Sharma.
Wait, Mr. Lordship.
Hmm.
Lordship, I beg to mention item 14. I have
Hmm.
instruction to this matter. This has
Hmm.
become
Withdraw.
infractious. Sir.
Building is complete. Mr. R. Sharma, learned counsel for the petitioner on instruction submits that the matter has become infructuous. Also, accordingly, he prays that the matter be closed as having become infructuous. Prayer is not objected to by the learned counsel for the respondents. Also, in view of the submissions of the learned counsel for the petitioner, the present writ petition is closed as having become infructuous.
Oblige.
Yes, Mr. Smith.
Now, with the concern of the other side, I beg to mention, my lord. For the principal, my lord,
Hmm.
is on behalf of the principal today. It posted after a week, my lord. Taking the concern.
Mr. M. Smith, learned counsel for the petitioner, submits
For the respondent.
for the respondent number 6, submits that the senior counsel, Mr. A.C. Barbara, a prayer is made on behalf of the learned senior counsel, Mr. A.C. Barbara, appearing for the respondent number 6 for an adjournment in the matter on account of personal inconvenience. Prayer is not objected to by the learned counsel for the respondents, for the petitioner. Also, registry to list this matter again. A prayer accepted, registry to list this matter again on 8 তারিখে পারি 8-9 কিবা কোন দিনা 16 on 16/9/2025. Miss N. Monto, learned D. Monto, learned counsel for the petitioner is present.
Much obliged, Lordship.
Sorry.
Hey,
Yes.
Lordships, item number 16 and 17. I am praying for withdrawal of these matters, my lord. 16 and 17. Actually, my lord, cause of action has been changed, my lord.
But in the both the writ petitions, you have the same prayer.
The respondents are different, my lord. Department is different.
Be that as it may, it's the policy finally at place.
When department, since
Why you want to withdraw?
cause of action has been changed, our circulation, rate of circulation has been changed, my lord.
But I'll only permit you to withdraw. That's all. Mr.
A. Chaudhary.
A. Chaudhary, learned counsel for the petitioner, on instruction submits that the petitioner desires not to press the matter any further. Full stop. Accordingly, he prays that the matter be permitted to be withdrawn. Prayer is not objected to by the learned counsel for the respondents. So accordingly, 16 and 17, the 16 and 17. Accordingly, the above noted writ petitions stand dismissed on withdrawal.
Obliged.
I'm praying for leave.
Sixteen to? Okay, we'll decide this, then that will follow. Nodal officer for? That's different thing. We'll consider this, and if required, we'll call for that, because I should not be, you make an application, you make your submissions in this matters, we will consider this then.
These matters may be taken up.
Today.
Lordship can take.
I'll go here. Rava. Anyway, you argue this matters, we'll consider that point also. Nodal officer appointment, we'll consider. You argue this matters today, 6 to 30. Yes. If required, we will hear the matter also.
Of the other side, I beg to mention item number 22.
Why? Huh?
He's in
Who is your senior? N?
Talukdar.
What happened to Mr. N. Not T. Borkotoki and your Rabha? Okay. Let us see what the stand of the... You have not filed a reply also here.
For the petitioner, your lord.
You're for the petition, I know that. They have filed an affidavit. You have not even cared to file a reply to that. What right of yours is violated here? Okay. A prayer is made on behalf of Mr. N. Talukdar, Lanaka Council, for the petitioner for an adjournment in the matter on account on the ground that he is indisposed. So prayer is not objected to by the Lanaka Council for the respondents. The registry to list this matter again on not I who got it. 16 9/2025. Call for it.
One more prayer, Lordship. I think we receive on
I ignored. We'll consider the repetitions only.
I
Who are you?
the president of the Anchaluk Panchayat Lordship.
Mr. Abedin is also appearing for the same party, no?
Lordship, and he's appearing for executive.
IA for what?
I
Pleading. What is your role here?
Lordship, the market that is in question that has been allotted by us, it is our market.
Okay, fine. Make your submissions, let the matter be called up. Consider yourself
We-
impleaded.
This morning, that may be come up along with the
Today we are not adjourning these matters.
Lordship.
You call for whatever you want.
Lordship,
That cattle market, we heard it. We'll complete it today. Yes. Mr. Goswami, you need not wait. We'll complete there is a long list. We'll complete it and then pass the orders there. Try to complete these 4 matters today itself. Your cases, we are only directing them to refund the money, KISS money, and that application for appearing before for that road that you have considered. There you establish, then they'll take a call. They'll take a call. The next matter is allowed, and Mr. Dotto, your case, naturally they could not establish that they were your employees. So we cannot come in. We'll have to uphold the view of the tribunal. That much only. Mr. We are allowing your writ petition, but I'm not sure whether I'll be able to do it today. In the end of the list, I'll try to do it. We are allowing your writ petition, Mr. Kandeli.
some other day may also. be
No,
fixed.
but let me see. I'm ready with the matters. I'm ready with the matters. If the list is over by earlier, we'll pass the orders to.
Fine.
Yes.
But I'm requested by Mr.
S. Borua means?
Pollution Control Board. After something.
We can't make Mr. Monto be here for the whole day.
No problem.
This is a stone crusher. Mr. Hazarika, you are in operation of that today. Now, it has a history. Today, you have filed an affidavit saying that the land has been changed.
With some other documents.
Consider as in. These are things which have happened after the challenge was presented. These are not to be taken care. We will only be concerned as to why you were given a revalidation of your NOC to operate the thing. Now, tell me one thing. The initial application of yours was allowed by only a public meeting. There was no examination as to whether your, Mr. Borua is here, whether your stone crusher would meet the requirements of noise pollution or air pollution. Then they come to a conclusion that no, this operation of this being in a residential area, this should not be permitted, and they did not extend the district administration gave its views, and the pollution control board also did not extend your view. Then all of a sudden there is a move. There is a public meeting held. In the public meeting, certain identified persons were called by the Gram Panchayat.
First meeting only.
First meeting. Say after for extension. This is not a meeting where which can be construed to be a public meeting, because it was only to a certain people. It was given
Most
around
people
20,
Outside the affected area.
22 people were there from the affected and others were outside the affected.
Subsequent meeting, there is
Be that as it may. So a meeting is held and the people, let's say, have given their consent. It is only on the that basis that the Pollution Control Board.
is for close to establish was done only because of the complaint,
Fine, I got it. I got it.
only because of the complaint.
Okay, fine. Now it has been again opened. But where is the scientific examination done at that stage?
That will. be
That is not
subject
there
to,
in their affidavit also. Rather,
because
Mr.
they-
Khajorika, just let me take it out. Their affidavit reflects that noise pollution is established. But air pollution, there is some ambiguity. But the particulate matters falling in the area is not disputed. And it's a residential area.
I'll submit, my lord. Let first submit his comments on the air pollution.
Okay, we'll hear Mr. Bonto. Yes, Mr. Bonto.
My lord, that is the basic thing, my lord, where the Pollution Control Board acting on a, my lord, report, they have cancelled it. And basic two things, my lord. My house is, my lord, only 30 meter, my lord, away from the, my lord, that stone crusher mean. That is not been answered by anyone, my lord. That is not been denied.
No, we will not go into that. We will
My
go
lord,
by the, whether the,
my lord.
Mr. Monto, whether the procedure that is required,
Not been followed.
that has been
No.
followed or not followed. You just demonstrate that.
Yes, that is not been
There
followed,
are two stages here.
my lord,
One, he was given without your participation.
my lord.
Rightly, wrongly, he was given a NOC and then a consent to operate. He operated. Then you had a grievance, you submitted an application.
Right.
District administration comes in.
Already by the pollution board, already the consent to operate.
No, district commission, the authorities come in, they write, and the pollution control board does not extend. Then another phase comes when he again goes back and the matter is the pollution control board requests the district administration to look into the matter. Then the district administration takes up. Those meetings are held.
My lord.
And in basis of that meeting, this was given. While giving this consent, kindly reflect from the materials available on record that there was no scientific examination made.
Absolutely not. my lord.
That you
That is not
just.
reflected. Your lordship kindly see the inquiry report, my lord. Apart from that, there are two another more important things that is not been considered, my lord. Because that as per-
Inquiry report is at 131.
my lord. Here is no question, probably.
So this is the basis for the revalidation of the
My lord.
NOC.
Your lordship kindly see the last part of the, my lord, last part of the inquiry report.
Page 133.
Not what corner, no? Nation my corner.
You are still operating it?
In the name of the wife,
It's being operated.
consent to operate is.
And you, no, are you operating the stone crusher? What is that? No, are you operating it? Mr. Monta, is he operating the?
My lord, actually, always, my lord, that real owner is something de facto and de jure is something different.
No, whether
Yes, sir.
that stone crusher
Yes,
is
yes,
functioning there.
Funny, my lord.
I can say only that operate,
No, whether the stone crusher is crushing stones. You obtain that. So this is the basis,
My lord,
page 133.
133, my lord, your lordship kindly see that inquiry report, last part. As per opinion of the public who gathered and venue that of time, last page, my lord, your lordship.
In the opinion of public who gathered.
And the date fixed for the hearing, it was seen that large number of public wanted to ambush unit to be operating with the proper system of the arrest in the so and so. But see, Dinesh Soikia, he would shifted the unit from the present location if he entire expenditure incurred in the setting up the unit was refunded. Therefore, as a majority of the local public is supported the proposed stone crusher unit, Amburi Khat stone crusher unit should be allowed to operate for the present location with the argumentation of the proper system of arrest in air south pollution till such time this initial investment is recovered to some extent. That was, my lord, his pair also, my lord. And there is no, my lord, inquiry report does not reflect that these parameters were being examined.
Hmm.
And another very important, my lord, your lordship kindly see, what is his land? His land is only one bigha,
You require 7 bigger.
7 bigha.
Whether the rules have been notified,
No,
finally?
no.
Have been notified.
No rules have been notified. When?
Yes, rule has been notified. The Assam Gazette number 393 notified on so and so.
Where is the rule?
Rule, my lord, that is not been annexed, my lord.
But the contention of one of the parties is that the rule has been notified in the Gazette. But in terms of the provisions of the rule, a further notification is required from the government for its implementation. Whether that notification has been issued.
But it was notified, it is published on
Gazette notification we
It's
have
there.
found from the pleadings.
my lord.
But whether yes, Mr. Borua, has the rules been notified for implementation?
2013 rule. That stone crusher. Yes, it is there.
No. It has come in the, you have the copy of the rule?
But it was not notified in the,
Why? Gazette edition published hoise.
You have it, Mr. Hazarika?
that RTI reply. The
Huh.
pollution
RTI reply,
rule is not notified.
Rule is not notified. When was it notified?
It is notified.
On 12th of June 2015.
Gazette.
I have replied to my RTI. Says that no, the Assam Stone Crusher Establishment and Regulation Rules 2013 till now has not been notified in the official. Is replied on 12th of June 2015.
It is there in one of your additional affidavits. Which is the page? It is at page 165. But it says it has not been notified in the official gazette, but
That is
Mr.
what
Monto,
As per the RTI reply.
Mr. Monto says that it has been notified in the official gazette. When was it notified?
Per my lord, my note is there. Assam Gazette number 393, notification number so and so, published on 17/9/2013.
(17/9)?
2013.
No, I have got it. It's here. But where is this rules? Did it? You have the rules, Mr. See clause 1 of that. Yes. This has been published. So, Mr. Monto, you can take your seat. Yes, Mr. Borua. This revalidation of the NOC or the consent to operate is after 2013. Why have you written that the rules have not been notified in the official gazette? Page 165, RTI reply.
Here replies of 2000.
But these rules already had come into place. In 2013 itself, 17/9/2013.
The rule of 2013, but notification hasn't been given.
Assam Gazette number so and so, notification number so and so, published on 17/9/2013. And 1(2) says they shall come into force with effect from the date of the publication in the Gazette. So these rules automatically apply.
Been in force since 13. So
13. So why was this not considered?
Here in entire case, so it's more with regard to the residential and industrial and
We are not concerned with that.
as
That's my second, that will be the second query that I have.
first is with
First
regard to
is,
the area.
first is whether these rules have been reckoned while you gave a consent to operate. Not initially, subsequently. You stalled it, then you gave it. So whether these rules were taken into account, one. Two, when you gave it the consent to operate after the inquiry report, there was no further scientific examination made. In your affidavit, you have brought in many parameters, but those were not the materials which you had considered when the consent to operate was revalidated. It was only on the basis of the inquiry report. And the inquiry report is nothing. Where is the second notification issued by you asking, allowing him to continue
Please, my lord.
in the writ petition?
PTB it is page 42.
40?
Reviewed by the respondent take.
First affidavit.
Page, read petition, page 52, my lord.
50?
52, read petition. Order dated 8 September 2014, in view of the receipt of the complaint and but has a lordship body, page 52, my lord.
Okay, where is the consent to operate thereafter? Affidavit, page? Page. Your affidavit, respondent number 10.
First affidavit.
Page, internal page? Huh?
Next one.
This is the subsequent one. This is the initial one. No, after page 52, 8/9/2014. This is 8/10/2014. Okay. The inquiry report is dated, Mr. Huh. Page. Hmm. No, this is subsequent one after the public meeting inquiry report. It is after page 42, 43 was issued. Hmm. After reaffirmation. Okay. Fine. So, Mr. Burwa, we are now required to look into only page 42 and 43 for the time being. 42, upon receipt of the inquiry report, you permitted 8/9/2014. You reiterated your consent to establish, right? Right? Last paragraph, there are some terms and conditions given. Then on 8/10/2014, you gave the consent to operate. What had happened in between these two? What is the satisfaction you drew? Mr. Monto, this is the issue.
This is the issue, my lord.
You have your say.
Regarding that notification, I have to take a print out on because it is a note, my lord.
This one.
Yeah, yes, my lord.
Okay.
There is a note only, but I will, because it is notified in my lord. Already there is a note written there.
Now we'll have the clarification. Don't worry. Yes, Mr. Burwa.
For that matter, to date of, so that is 8/9/2004.
The report is not 22/9, it is 21/8/2014. The inquiry officer's report. 8/9/2000.
Then again comes 8.
Huh. Hmm.
So what else in between?
Hmm.
this?
Hmm. Hmm.
In 15.
Hmm.
That-
Hmm.
PPA.
So what is the material that he had satisfied the requirements you have put in place?
Requirements are the doc.
What are those? No, I'm not on that. I'm on the scientific examination.
Scientific exam.
That you required that he has to put in a proper system to arrest air and sound pollution.
Pre-noted.
So where was the satisfaction drawn that those pre-noted stipulations were fulfilled? I'm sorry, that is not the, while granting consent and ensure system to arrest air and sound pollution as set up by the board is installed and they start operating the crusher only after obtaining the consent to operate by the board. So these systems have to be put in place. You have to draw a satisfaction. Okay, who has drawn that satisfaction that before 8/10/2014, these systems were in place? Rather, your materials that are there on record, your affidavits and your inquiry reports shows that at least on one of the parameters, noise pollution, it was not fulfilling.
But for that matter, time to time monitoring has been done. after
No,
the
I'm on the initial part.
that initial.
What is the satisfaction you have drawn and how you have drawn?
Just now I have referred to the official note of 22/9/2014.
Hmm.
Subsequently, the public complaint has been received and thereafter inspection has been carried out. So this is reflected here. Bill number 136 to 1 may kindly be seen. Messrs. Amguri Khat Stone Crusher has applied for the CTO for the year 2015-16. The unit has deposited so and so with duly filled application. Right, and found to be in order. Order processing the application, draft put up for your kind approval. So
This is dated, notice dated 17/3/2015. But you had already granted it in this is October 2008, 10/2014. You have already granted.
no, that was granted, but public complaint.
So
has-
how do you grant that?
Public complaint has.
You don't
surfaced.
draw any satisfaction before grant of CTO that the conditions which were given to establish, consent to establish have been fulfilled.
Condition precedent to the consent to operate are already enumerated in the consent to establish.
That's what I'm saying.
If at all.
When you gave this 8/10/2014, where is your satisfaction drawn that all those conditions have been put in place, satisfied, and then you proceed?
The very cause that the consent to operate has been granted means thereby that.
No, cannot be. You'll have to demonstrate that.
No. Normally those are the parameters.
You
which
just
have to
tell
be
me
fulfilled.
that in the consent to establish,
Yes.
you had required him to put in a proper system to arrest air and sound pollution. These are the two conditions you have set out.
Yes.
So where is the satisfaction that these two conditions were fulfilled by? That the systems were in place? That much only. Forget whether that operation of that crusher, whether the system failed or not, there was complaint you made further, that's subsequent. But that you had set out certain conditions that you will have to have these systems for arresting air and noise pollution, then we will give you the consent to operate. Show me what is the system he put in place and how you drew your satisfaction.
Till now, I haven't come across any of the units where a specific and detailed report is being given in the consent to
No.
operate.
At least
Ultimately-
at least your satisfaction.
Till the time-
You come to 8/9/2014 order,
Is
page 113, page 42 of his affidavit by Mr. Hazarika. Under 13. Where is this order? 22/1/2014. writ petition. Page
Page 36.
Okay, Mr. Borua,
Yes.
come to page 36.
Mm. 22nd of Jan, 2014.
So this is the satisfaction you have drawn. Kindly read that.
Reference public complaint received on
No, no, you can consent to appeal. You
consent
can
to
read that.
establish order,
So and so.
right letter number dated 19/6/2010
On the ground.
has been withdrawn on the ground that the present site is in close proximity to the residential area.
Hmm.
The dust and sound generated from the crusher during the operation is likely to cause health hazard to nearby residents.
Hmm.
As per consent to establish order serial number 20, you are directed to stop installation work of your stone crusher as the environmental condition of the area is changed now as compared to the year 2010 when the NOC was granted.
Hmm.
Yes.
Hmm.
So-
So you recognize two things here. That it's a residential area. Two, that this unit will cause health hazard, right? Then he comes up before you. You give him, you direct the district administration to look into the matter. The district administration's report is only to the extent that the people, let's hold that people had given their consent. Public hearing held, a consent given. Now, then you immediately basing on that, you proceed to reaffirm the consent to establish, right? What measures have you, what satisfaction have you drawn in your report? After 8/9/2014, before 8/10/2014, that at least the presumptions you drew on 22/1/2014 were not there. Because now you come back to 8/9/2014. Read the last paragraph.
As Amguri that stone crusher are allowed to establish the unit in strict observations of terms and conditions while granting consent to establish and ensure proper system to air and sound pollution as said by the board installed, and they start to operation of the crusher only after obtaining consent to operate by
So now you have 22/1, you have 8/9. There are certain things peculiar to this operation of Amguri Hut stone crusher. Now, where is the satisfaction? What is the satisfaction you drew before 8/10/2014 that at least these things have been put in place?
Definitely there has to be an examination of official examination.
Where is that?
For that matter, I will just
You can go through and also get me the information as to when this 2002 rules were notified in the official gazette. 13 rules were observed. We'll have it at 2 p.m. Mr. Monto, at 2
My-
p.m. This is the only issue we have
Yes,
to.
my lord.
Whatever you have done thereafter cannot negate this non-drawal of satisfaction you had to draw
initial.
on 8/10/2014.
Plain only.
Mr. Hazarika, the complaint 22/1, when they had withdrawn it, they had withdrawn it on specific grounds. That is what I'm saying. Then the inquiry by the district administration.
Noted. There is a letter, perhaps it is in the record, only because of their complaint, it was.
I know that. I know that. I know that. But the complaint,
improvement.
Mr. Hazarika, complaint satisfaction was drawn that it is in a residential area. 1. 2, that it is causing, it would cause health hazard. So when they gave you after this inquiry report and all, inquiry report is only to the extent of the, what do you call that, no objection from the public at large. Let us hold that it was given. But where is the satisfaction drawn that you had put in all required systems after 8-9 and before October 2014 when CTO was given to you? That much only.
I want to explain, my lord.
We will hear you.
Only because of that public complaint, was made.
And now the 2013 rules, Mr. Hazarika, if the 2013 rules is already notified, then
Was, granted in the.
it was cancelled. It was cancelled in 2014. It was cancelled in 2014 because of the change circumstances, and
Yes,
the
it
rule
is.
also takes into account that. Rule.
Granting 2000, in 2010, that withdrawn was.
You have, Mr. Hazarika, you have also operated that for a long period of time now. So now I think it's high time that you shift out in terms of the
Inquiry report.
inquiry report.
That inquiry good, I'll show the ambiguity, my lord.
It is not been challenged by.
Coherence in my prayer, my lord. I'll show that.
Your inquiry report is defective according to you.
Well,
And
the last-
everything,
the
whole
last-
edifice falls through.
No, the last paragraph he has shown, my lord.
Hmm.
When it will, my lord. I'll show. Yes.
Have you challenged that inquiry report at any point of time then? Okay, let Mr.
My lord.
Mr.
I'll try to find it out right.
If it is done, then it will be a different
Different.
perspective altogether. We'll have it at 2 p.m.
My lord.
Any inconvenience, Mr. Monto? No?
One.
Okay.
Item 6 to
We'll take up one by one. So your applications were rejected at page 30,
In order, my
a single line order. That's all. So, but they have not disclosed anything.
Act says that the order should be passed.
Uh.
And Act also does not permit the authority to reject my application. They cannot issue, they may not issue with us NOC,
But they'll have to give a reason for
they
that.
have to give a reason.
So that reason admittedly is absent here.
One more thing, my lord, now the affidavit they have come up with certain documents where they are ready with those documents.
You give it,
We'll submit the documents.
you
let
give
the
it,
reconsider
we will
our
ask them
application.
to look into it because admittedly your application was rejected without a speaking order. No reasons. Huh?
Plus, produced at the very first day also, my lord.
copy.
What is the name of that case?
Others.
Trying the regions.
So do one thing. Now that you have rejected it, communicate the reasons to him. within a period of 15 days. Another 15 days, he will give you a reply. And thereafter, within another 30 days, you dispose it off with a speaking order. If any document is required, he will furnish.
I'm ready to, Malad.
You will have to.
Produce.
That
the-
much only. Why keep this matter pending? Because we cannot take a call here. This call has to be taken by the first case. It is only rejected. In all the cases, it is only rejected.
Only
And you have filed an affidavit in all the cases.
all the case.
All the cases, mismatch of documents. That much only. Huh? All are mismatch of documents. Same order also both, Heard Mr. Ayat Sekya, learned counsel for the petition. Also heard Ms. M. Borman, petitioners, learned counsel. Who is appearing for the, Mr. Doctor, you are appearing. Mr. S. Doctor, learned standing counsel, revenue and disaster management, appearing for the respondent number 1, and Ms. M. Borman, a learned government advocate, appearing for the respondent number 1 and 2. The petitioner, by way of instituting the present proceeding, has the rejection orders are dated same date.
Same
Can your friend just give me a date?
I'll give the chart, my lord.
Chart, just give me a chart and the reason. Reason assigned.
That is only
Rejected.
Only
Okay, fine. Has presented a challenge to an order dated 10/2/2025 passed by the circle officer. This is by the circle officer. By the circle officer, which circle?
Corporate revenue circle.
Corporate Revenue Circle, rejecting the prayer of the petitioner for being granted a composite, granted no objection for sale of land of the petitioner number 1 herein to the petitioner number 2. Full stop. The petitioners project that in all the cases, it is the petition number 1 who is the vendor. Some difference.
That is, I have prepared the
Ah,
chart.
okay. It to me WPC 2315 would like huh? So the petitioners project that the petition number 1 is the absolute owner of a plot of land measuring 15 lesa covered by DAG number 146, under Patta number 102, situated at Howley Town, Borpeta Revenue Circle, Borpeta. So, the petition number 1, herein, had agreed to sell the said plot of land to the petitioner number 2. Also, accordingly, the said agreement having come around and joint application was preferred on 6/2/2025 for issuance of necessary no objection certificate for transfer of ownership of the plot of land in question. Also, the petitioner's content that the said application was so made in the portal Heva Hetu apostrophe Hiba. And the requisite fee for the same was also paid. Full stop. The petitioner's further content that the application so submitted was application dated 6/2/2025 so submitted was done strictly in accordance with the procedure mandated. Also, the materials brought on record further reveal that the application of the submitted by the petitioners were processed by the respondent authorities and the jurisdictional Lat Mandal had submitted his report in the matter. Also, the application was forwarded to the jurisdictional service circle officer, who, on perusal of the reports available in the matter, proceeded to reject the same on, when was it rejected?
10 to 2025, my lord.
10 to 2025. The rejection was, was stated to have been so made basing on the jurisdictional Lat Mandal's report. Also, the petitioners, on perusal of the portal, had come to learn about the rejection of their application on 11/3/2025. Full stop. Being aggrieved, the petitioners have instituted the present proceedings. Mr. I.H. Soikya, learned counsel for the petitioner, after reiterating the facts noticed herein above, has submitted that the rejection so affected of the application submitted in the matter by the petitioners, was so done without any reference to them. First, he submits that in the event there was a lacking of any documents along with the application submitted by the petitioners in the matter, the authorities were duty bound to extend an opportunity to the petitioners to submit the deficient documents. Mr. Saikya submits that the circle of in the portal, the rejection of the no reason has been assigned for rejection of the application submitted by the petitioners herein, and it has been only noted as apostrophe rejected. Also, accordingly, Mr. Saikya submits that the respondent authorities be directed to reconsider the application of the petitioners by affording an opportunity to the petitioners to furnish the deficient documents. Full stop. Ms. M. Burman, learned M. Burman, learned government advocate, submits that the application submitted by the petitioner was rejected on account of the fact that there was a mismatch with regard to particulars set out in the application so submitted in the matter, as well as the documents accompanying the same. She submits that there is no provision made in the portal for disclosure of reasons for rejection of the application. And the application not having been submitted by complying with the procedure prescribed in the matter, the same did not mandate further consideration, and accordingly, the application submitted by the petitioner was petitioners came to be rejected. She further submits that the application on being rejected, the portal does not permit its reversion to the authority who had put up the note in this, whose note was relied in this connection, and after a rejection of such application, a fresh process of hearing cannot be granted, inasmuch as the processing of such applications is always done in a time-bound manner. Also, I have heard the learned counsel for the parties and also perused the materials available on record. Also, The facts noticed above are not in dispute. Also, sure, para 9, 10, 11, 12, 13, 14. Also, in 17, 18, 19, 20, 21, 22. So, the petitioners, এইটো খালি তুমি এটা জায়গাত নোট কৰি থৈ দিয়া মই পিছত এইখিনি কাটি দিয়া মই পিছত দি আছো. The petitioners herein had submitted an application in the portal, it's called a portal, in the government portal, Hewa Hetu, seeking a no objection certificate for transfer of the land of the petitioner number 1 to the petitioner number 2. Also, the said portal is being so created under the provisions of the Assam Right to Public Services Act 2012 bracket as amended and section 21A of the Registration Act 1908, comma, as amended by the registration bracket Assam Amendment bracket over Act 2009. এতিয়া তুমি লিখা para 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 20. WPC 1710/2025, huh? Also, a coordinate bench of this court on consideration of an issue of the issue arising in the present proceedings in the case of Simanto Mudai and 2 others, bracketed, judgment and order dated 3/4/2025 in WPC number 1710/2025 had drawn the following conclusions. Para 14, yapa quote koriba. Itia quote koriba. 15, 16, 17, 18, 19, 20, 21, 22, 25, 26, 27, 8, 29, 30, 31, 32, 34, 33. Like. Also, on perusal of the conclusions and directions passed by the coordinate bench of this court in the case of Simanto Mudai, Supra, this court is in respectful agreement with the same. Also, this court further holds that the directions, that the conclusions drawn by the coordinate bench in the case of Simanto Mudai squarely would also squarely cover the issue arising in the present proceedings. Also, accordingly, applying the said decision to the facts or said decision in the case of Simanto Mudai to the facts of the case, comma, the impugned order of rejection dated 10/2/2025 being not in the nature of a speaking order, comma, the same stands interfered with. Also, as the order dated 10/2/2025 has been interfered with, comma, and there being a obligation on the part of the designated public servant to consider the application submitted by the petitioners for the notified public service, apostrophe, composite land sale transfer, apostrophe, close, quotation close, the designated public servant is directed to communicate to the petitioners herein, the reasons existing for rejection of their application. Also, the petitioners, on receipt of such communication from the they said communication be so issued within a period of 15 days from the date of receipt of a certified copy of this order. Also, the petitioners, on receipt of the said communication, shall submit a representation against the reasons so assigned therein, along with the requisite documents in justification of their respective claims. Also, any document, I'm not making it, full stop. The designated authority, designated public servant, on a receipt of the said reply from the representation from the petitioner, shall consider the same strictly in accordance with the provisions of the Assam Right to Public Services Act 2012 as amended, the proviso to Section 21A of the Registration Act 1908 as amended by the Registration Assam Amendment Act 2019, and the notification dated 11/11/2022, as well as any other binding decisions of the competent authority of the Revenue and Disaster Management Department, and thereafter pass a speaking and reasoned order within a period of 30 days from the date of receipt of the representation, above noted representation of the petitioner. Full stop. With the above observations and directions, the present writ petition stands disposed of. This order will follow in the other cases also. Taking my idea, mabaki diya sir. Huh?
Taken the mutation also, submitted the.
Also, it is at this stage, Mr. Saikia has submitted that the fees are requisite for the purpose having already been paid by the petitioner in terms of the provisions of the said Act of 2012, no further fee would be permissible to be received from the petitioners in this connection. Full stop. In the event the fees as remitted by the petitioners is in satisfaction of the requirement as made in this connection for the service concerned, no further fee shall be claimed or shall be demanded from the petitioners in this connection for carrying out, for complying with the directions passed by this court hearing above. I'll put it in. Don't worry. You will have it day after. Whatever. তুমি মোক এইটো টাইপ কৰি দিলে হ'ল, এই দুটা তুমি ৰাখি থোৱা। এইটো নেপেলাবা এইটো খালিখিনি দি দিয়া। এইখিনি disposed of দেই। 6 to 13.
15.
Please, my lord, I have all copy to consent as Dr. My lord.
Yes, Mr. Doctor. What is this?
Lord, I have also as per honorable direction, my lord, I have assistance, my lord. Is 7, that is my Panchayat and Rural Development, that is the necessary party, that case, my lord. I have pursued the.
You have not filed it.
My lord, already I have went to filing section. They have denied that in one page they are not accepted.
So you'll have to give the full one. from the first page onwards,
First
you will have
page-
to give, there is a procedure prescribed.
First page to whole petition, my lord.
No, the top, the page 1 to 7, I think you will have to give. That's the procedure. You can't give a single page like this.
Okay, my lord, I am next time I have.
You do it immediately. Yes, Mr. Dotto.
Commissioners will be- my lord, they are claiming like two, my lord, they are forest dwellers. And government affidavit is saying, my lord, BCR land.
There is a statement by the Council for the Forest Department that these people are in forest land. And they
Government
are,
is saying it's a BCR land.
forget the government, that they are dwellers, forest dwellers, in terms of that Scheduled Tribes Protection of 2006 or something act. Second is that these petitioners, with regard to that land, you had granted them houses under the IAY scheme. What is your take on that?
At ground, my lord,
No, that is exactly what you were supposed to do.
but actually copy was served lately, my lord.
Lately, how lately?
That date.
It was submitted in July
Right.
to you.
I was not there. My lord.
The copy, my lord, on, my lord, went on a.
But my lord,
Same day I have.
tell my lord, with the land, my lord.
That is the doubt we are having. Who has this land? Because it is the claim of the Forest Department that since 1948, they are staying in forest land and you have given them IAY. If it is a VGL land or it is a forest land, how could you have given them you can give. So in VGL land, you can't give. So their position stands affirmed.
The procedure, my lord, for the government.
Okay, fine. The land that is there, there is no verification of the land.
Our side, we cannot, my lord. Ram Sabha if approves, my
So it is basically a forest land.
Not clear, my lord, that is
May-
forest
may
land,
direct, my lord, there will be
government
joint
advice.
verification, my lord.
It is not joint verification, maybe kindly.
We'll have the joint verification. And why have you not filed a affidavit in reply to the affidavit filed by the government? Because therein they have said that this is VGR land. If it is VGR land, you have got no right to stay there, madam.
Time, my lord, I have
Okay,
filed a affidavit, my lord.
Establish a protection also, my lord, as per the act. There are some procedures, my lord.
But why this statement was recorded of the government, where the Forest Council, that they are,
Sorry, my lord. Forest Department's affidavit is also.
who is appearing for the forest? Yes, Mr. Gugoi, what is the case here? No, you have instructions. That is the order dated 26/7/2024. In this case, 26/7/2024. The Learned Standing Council for the Forest Department submits that he has instructions that these persons are forest dwellers and the Forest Department is not intending to evict them from the land. However, he would like to file an affidavit to that effect. Accordingly, he prays for an adjournment. So on two counts, IAY House and your statement, this court said we'll have to examine this matter. If they are forest dwellers, the government has got no jurisdiction to evict them. And Mr. Dotto says IAY schemes are permissible also in the forest villages. File an affidavit to that effect. Mr. R.R. Gogoi, Learned Standing Council, Forest Department submits that.
So file one, if it in reply, my lord, on.
Submits that. He be granted 2 weeks time to file an affidavit on behalf of the respondents represented by him. Also, Mr. S. Dr. Learned, Standing Council, Panchayat and Rural Development Department submits that he would also bring on record the stand of the department represented by him within the next 2 weeks from today. Also, Mr. N. Das, Learned Counsel for the Learned Government Advocate appearing for the respondent number 3 has submitted that an affidavit on behalf of the said respondent has already been filed in the matter, and the same would reveal that the petitioners were occupying VGR land. Full stop. Considering the rival submissions of the parties to the proceeding and also the stand taken in the matter by the Forest Department, this court is of the considered view that the affidavits on behalf of the Forest Department as well as the Panchayat and Rural Development Department is required for a proper and due and proper adjudication of the issue arising in the present petition. Full stop. Accordingly, registry to list this matter again on (17-9) 2025. Full stop. In the meanwhile, the respondents, including the respondents in the Forest Department as well as the Panchayat and Rural Development Department, shall without fail bring on record their respective stands by way of filing affidavits. Full stop. The petitioner is at liberty to file its rejoinder to the affidavits that has been filed or would be filed before the next date of listing by the respondents. Full stop. Registry to 19 question. The affidavits be filed by the respondents 19 26 27 ko area. The respondents are directed to file their affidavits on or before 21/8/2025. 29 December to me date to 29 ko area. Also.
This is a general, my lord, paper, my lord.
Forget it. Those things I need.
Except this paper, my lord, there is nothing.
But that's what we want. 2-3 orders this court has recorded IAY house. Show it that you have not given. Finish. That's the end of the matter. 24. On or before 18 ko area. 18/8/2025. The petitioner shall thereafter file its rejoinder on or before 27/8/2025, registry to list this matter again on 29/8/2025. Petitioner shall also in the meanwhile file the amended cause title as directed by this court earlier. So you file your affidavits by 18th. 18
17.
September, and we'll have the matter on 28th to Bondo. A more date bullish. 26 ko area.
September, my lord.
September. 24 to without rejoinder file.
Ali.
Yes, Mr. Huh?
This matter has become infectious. So after passing the termination order, my lord, the work was given. Third party completed the work.
But your holiday list,
Yes, my lord.
that is a
That has been stayed.
that has been stayed. So
Yes,
we'll
my
have to
lord.
now verify whether that stay was proper or not. That much too we'll have to do. Whether the stay was correct, then we'll quash it. If not, we'll have to say that the stay order was wrong. We are vacating it. Consequences, what are
It is correct. The order which has been granted by this honorable
It's temporary in nature, so we'll have to give it a permanency either way. So you'll have to make your submissions on that. Why
it is so?
is needed to be approved, or it has to be said that, okay,
Yes.
that is quashed.
That one I did not. Let it come day after tomorrow, why not?
I'm sorry, day after tomorrow, it's not possible. It will be possible
Okay,
only
convenient date.
after. 29th. 5/9, okay. Mr. O.P. Bhatti, Learned Counsel, appearing for the petitioner, submits that he be accommodated today and be permitted to make his submissions on 5/9/2025. Prayer accepted. Registry to list this matter again on 5/9/2025 for admissions. Only that much, Mr. Bhatti. We will have to pass on.
That's all right.
My lord, we have received the copy of the affidavit filed by them. So if you have huge time,
When did you receive that, Mr.? On 19/8. Mr. K. Sharma, Learned Counsel for the petitioner, submits that an affidavit on behalf of the respondent number 3 has been filed and a copy served on the and a copy has been served upon him. Also, he prays that he be granted a 2 weeks time to file a reply, a rejoinder. 3 weeks time to file a rejoinder thereto. Prayer accepted. A registry to list these matters after 3 weeks on a date to be fixed by it. Yeah, Gaurav, not too much change. 18/027.
please be my lord. Lordship, this is a
18.
claim for
Tara, go to. Item number?
20, lordship. This is a electrical
Yes.
bond injury, lordship.
Huh?
So the severe injury, lordship, of a minor girl, lordship. He still studying, lordship.
Hmm.
He would like.
There was one clause here that he can go and claim it from the civil court also. Huh. What is the amount that would be now permissible to be paid? Where is that quantification?
711.
Four lakhs.
Interest 12%. Yes, interest 12%. And lordship, here I would like to give certain rulings of our Guwahati High Court.
It would be 4 lakhs.
Interest 12%, lordship. Probably date of accident. I would like to give lordship certain rulings of our owner Guwahati High Court and Supreme Court, lordship. Here lordship 25 lakhs has been awarded and Supreme Court 1 crore 25 lakhs reduced to 90 lakhs, lordship.
Okay, now you tell me how that is permissible to be done here.
Here and our owner Guwahati High Court, lordship, recently in my case also, that 4 lakhs plus 12% interest.
That 4 lakh plus 12%, it's okay. It's your, because the electric inspector's report is there.
Yes, yes. Now Guwahati High Court has given this 25 lakhs. Court 1 crore 25 lakhs has been reduced to.
Mr. Agarwal, if it is 4 lakhs plus 12% interest with further liberty to you to approach
Yes,
the
yes.
civil court,
No problem.
I am
No
passing
problem,
it.
lordship.
But if it is, you want a amount higher than this,
Yes.
satisfy me without making a challenge to that.
Liberty may
Okay.
kindly be given, lordship. And the amount may kindly deposit before the registry within 4 weeks, lordship.
How old is the girl now?
The girl is now studying in pathetic in lordship.
Now, what is the age of the girl now?
Girl is now more than 18 and 22 years, lordship. Now,
Her bank account would be given to the to the APDCL authorities. Mr. Agarwal, that is my headache, how I do it. You give the bank account number to the APDCL authorities. The money will be money plus interest directly transferred to her account. And that will be utilized for her future prospects. And there is a liberty to approach the civil court.
Even to the registry before, that will be time not consuming. Lordship.
I'll ensure that it is done within a period of 1 month directly to the account of the girl if she is a major. What is her age? She is a major. She has a bank account.
Now reading in Guwahati University, Lordship.
Okay, very good. She will use this money for her.
The condition, Lordship, we cannot see, Lordship. Photographs may kindly be verified.
I don't want to see also.
Lordship, but
I am concerned with her welfare and I'm doing what is required for that. Any objection?
Registry, if it is.
Show me the law that it has to be deposited with the registry. Just show me the law.
No problem, Lordship, will collect from their office, Lordship.
Why should you collect? That will be direct DBT, direct bank transfer.
Yes, Lordship, that will be done, Lordship. Then no problem.
No problem. If you have any objection, we'll deal with it, Mr. Ali.
No problem.
No problem.
The money should be go to the.
Give that particulars to the APDCL authorities. 1 month. That is there at clause 21.
Regarding the quantum of compensation.
So, Mr. Agarwal, if you have any issue with the quantum, please take recourse to. No. If further something is there, 21. That liberty I'll provide for. When was the accident? Date of the accident?
Accident is 27/4/15, Lordship.
2015. So what would be the quantum now? 4 lakhs plus bank
Interest.
12% interest.
Interest, my lords.
No, it will be from the date of the accident. And
The OMC.
50% of the amount would be kept in a fixed deposit account for her future prospects, benefits, as per her discretion, the girl's discretion. Dispose of.
Kindly, it may be listed and.
Make it ready, my dear.
359.
I'll see. Mr. Saraf, the only plea taken by the respondents is they are not denying that you have a surplus ITC with you, but for some reasons you have not been utilizing it. Their only plea in the reply is that the claim made by you is covered by Schedule 4 and no ITC is permissible to be computed for that. What do you have to say on that?
As far as the 4, it is not there. That is not the issue also. Who is that, my lord? 36/2017 was not utilized. From 1/7/2017, the GST came. Act says, my lord, if it has been utilized, not utilized, but not eligible, then it can be reversed. That was not done. If it was not utilized and remained in account, question of recovery and interest does not arise. The authority has funded the amount along with the interest, you'll also be just similar. Case 31.
Hmm.
Case for making this order has arisen upon the following facts. The dealer was found to have claimed excess input tax credit amounting to rupees so-and-so in the return filed by him for the month of June 2017 under the Assam Value Tax Act 2013. Your Lordship may kindly claim the input tax credit the month of June in the return of June 2017. Therefore, notice under so-and-so 6th May 2022 for reversal of the same and realization of the recoverable amount of the tax and interest on this count was served on him. Now here he says reversal as well as recovery of the amount. He has, however, failed to submit any satisfactory explanation in this matter. Therefore, the recoverable amount of the tax and interest is calculated as under. Now, my lord, Lordship looks into the section.
Page 11.
But there is no power. Page 11, Your Lordship may see. I take it likely to Lordship to my lord. 8, if the goods purchased were intended, I can skip over my lord. Item
9.
9. Your Lordship may similar. Without prejudice to generality of the provisions of this section 8, input tax credit already availed of stand reversed
E.
in the following circumstances. Where excess input tax credit has been claimed, this is not applicable, Lord. This is not excess. He is saying excess, but this is not excess.
This is your claim after the reconciliation.
My lord, this is their provision that, my lord, this was falling under bench in the schedule 4. And he was not entitled to the input tax credit.
Input tax credit.
This is not a case of excess input tax credit.
Okay.
Lordship, can you see me, Lord? Now,
So, Mr. Saraf, you had in your return projected this ITC, which was being carried forward. Two amounts were there, 82,000 and the balance. You were carrying it forward. And in 2017 returns, you had utilized that to pay the full amount to pay your tax dues. Right? Now, if that amount is with you, you can always pay that. Be that as it may, how they have structured the order. But there is a tax demand of that equivalent amount from you. No, I don't understand. That's why I'm asking you. Not utilized.
remained as it is.
As it is.
From 1/7/2007, the VAT Act has been repealed. And a special provision has been incorporated, which you'll also find in the 42. Yet you'll also see at 142 page 15. Where in pursuance of an assessment or adjudication proceeding instituted, whether before or after the appointed day, under the existing law, any amount of tax, interest, or fine become recoverable from the person, the same shall, unless recovered under the existing law, be recovered as an arrears tax under this act. And the amount so recovered shall not be admissible as input tax credit. Now, this under the old act, the act was repealed from 1/7/2017. The VAT Act has already been repealed. Prior to repealing of the VAT Act, this amount was not utilized.
No.
It remained as it is.
Hmm.
The authority which has passed the order
Hmm.
has passed the order for recovery of the amount along with the interest.
Hmm.
Which he could not have done because on 36/2017, when the VAT Act was there, the amount was not utilized.
Utilized.
Now, the question your lordship has raised, my lord, I pertinent question, my lord. That,
That I don't know,
no, my lord, this
but
is important question. my lord.
that's a doubt. Hmm.
It also came to my mind, my lord. After 1/7/2017, after GST Act came into force, he has utilized it. The GST law. Whatever proceedings, whatever can be taken, but the law and the GST law may be taken. But that will not validate the order which has been passed by the authority, VAT authority. Because 142(8) clearly says, my lord, that any amount recoverable can be recovered only under the GST law.
Not under the
Not under the
repealed.
VAT has been repealed. So this order which has been passed
Hmm.
is absolutely legal without jurisdiction. He has no power to order for recovery of an amount
Hmm.
which was not utilized at all during the VAT regime.
Hmm.
If the amount was not utilized during the VAT regime, then the authority has no power to order for recovery of the amount and the interest. He could have exercised the power of reversal. I'm not disputing that. He could have done it, but that was not done.
Hmm.
Till the VAT Act was there.
Hmm.
Now, if that was not done,
Hmm.
because your lordship knows, my lord, that when the order is challenged, your lordship,
Hmm.
you examine the action of the authorities on the basis of the order. Now, the order which is there is for recovery of the amount and the interest. Now, that is not at all permissible
Hmm.
under the law. Now, if under any other provision of law,
He can do it.
the GST authority, the VAT authority cannot do now.
Do it.
GST authority can do it, they may proceed.
So the notice that was issued to you on 6/5/2022 being for reversal.
Not reversal, no, this is,
No, if you can come to that.
my lord, may see.
Second paragraph,
My lord,
page 21.
page 21, my lord. My lord. Your lordship is the second paragraph, and where is it necessary to reverse the same as per the provision of so and so, and recoverable demand of tax and interest in this count is
To be realized.
Where from?
Power is
Which
on.
of recoverable. I have given reply that I have not utilized it. The question of recovery does not arise. And he has given that the explanation is not satisfactory. What does it mean, my lord? My short submission for your lordship is that, my lord,
Power is not there.
on 36/2017, the input tax credit having not been utilized, the question of recovery and the levy of interest does not arise. And in that view of the matter, order which has been passed is absolutely legal without jurisdiction, liable to be set aside. View of section 142 of the Act, GST Act, which I quoted, at page 15, my lord. Where in pursuance to the assessment of the adjudication proceeding instituted whether before or after the appointed day, that is 1/7/2017, under the existing law, that is VAT law, any amount of tax, interest, fine or penalty becomes recoverable from the person, the same shall, unless recovered under the existing law, be recovered as an arrear of tax under this act, and amount so recovered shall not be admissible, so and so. So the proceedings will have to be initiated under the GST law, if they so want, in accordance with law. That option. But the lordship, in my humble submission, cannot construe the order that it will be treated to be an order of reversal. No. Because
There is no reversal now.
there is no reversal on by the order.
But the notice was for reversal.
What is for reversal?
And you mean to say that after 2017 March
Actually for reversal, it says reversal
and
recovery of the amount.
amount,
Both is
both
in the order also reversal and recovery of the amount.
together.
How the amount, if it is reversed, how the question of recovery and interest will arise? Look, interest can arise only when
No,
somebody.
and they say that the mistake is in the final order. Given the fact of jurisdiction, subject to, for my understanding, here it is says that it is a reversal and the recoverable demand of tax and interest on this count to be realized. But while they pass the order, they say principal amount of input tax credit so and so, payable interest so and so. So they made an error here.
The question is that, my lord, recovery can only be done when the input tax credit account 1 lakh rupees.
This is there. This amount is there.
This amount was there.
Mm.
I have not utilized it.
Mm.
If I have not utilized it, it can at best be reversed.
Mm.
It cannot be recovered.
It cannot be. That order is wrong.
So on that score, the order which has been passed is
Is wrong.
illegal.
Is illegal. Yeah, that is accepted.
Now, the question will arise, my lord, that whether at this stage, the authority can pass the order of reversal.
Hmm.
That cannot be passed.
Because the act is already gone.
It is already gone, and I have utilized it in the after coming into force of the GST law. So this input tax credit has to be carried forward from 1/7/2017 for the GST. Or rightly or wrongly, I have utilized it against the GST liabilities. There is no question of VAT liability now, my lord. It has been utilized against the GST liabilities. Now, if the GST liabilities, this amount has been utilized, then any recovery or reversal, anything,
Will be by the GST authority.
GST authorities. And that has to be done as per the provisions. of the act.
142.
Let them do it.
Is it permissible now to do that?
My
There is
lord,
a time limit.
that's why I am saying, my lord, in accordance with law.
Okay, understood. Yes, Mr. Gogoi.
Lord, in Suram Potteries,
Hmm.
107 ITR page 1. 107 ITR page 1 says,
ITR SC 1.
see, what said, my lord, that the tax authorities are expected and they should be compliant with the tax laws,
Of.
administration of the tax laws. And if they are not, and thereby commit any mistakes,
You should not be put to
the
trial.
revenue has to suffer. But this is the same thing, reverse side on the SSC. If SSC commits any mistake,
He'll suffer.
then he has to suffer. There is no equity in taxation. One cannot say that, no, for department committing the mistake, they will get the benefit, and SSC committing mistake. If I commit a mistake, don't submit my return by the due date.
Then you are supposed to be penalized. for
Whether, it was by mistake or something that is not
That
so.
will not come.
So, my lord, that's why I am submitting that without going into that issue, the GST authorities may be given the liberty. They so desire to proceed in accordance with law. No objection, if necessary, second round again will not be there. But at least this order
This order cannot stand.
cannot be. That is my short submission, follows.
Mr. Gogoi, what I've understood from the submission is that he had a input tax credit at his account. Rightly or wrongly, he has given an explanation also that at the time there were some disputes with the person from whom he had bought the goods. It was reconciled. And finally, around 24 lakhs odd was the input tax credit. 36/2017, the VAT Act goes and the GST comes into being. He thereafter submits his return for that period and utilizes that amount in satisfaction of his GST demands. Just correct me if there is any factual error. So you in 22 issue a notice to him, one, for reversal of that amount. If that amount is reversed, there would be a tax demand. For that, you will have to now calculate a interest also. A submits its replies, saying, I have never utilized this amount, this, that, whatever it is. Now you pass an order. This order justify, page 31, he has, however, failed to submit any satisfactory, therefore the recoverable amount of tax and interest is calculated as below. Here what you are trying to do is you are recovering the input tax credit, which admittedly the petitioner had never utilized.
But whether the petitioner was at all, my lord, entitled at the very beginning for the provision of the VAT, they are not entitled for the input.
But where have you reversed it? Where is the order of reversal? You have not. Another thing, there is a plea taken that in every account, every return he had filed, this amount was demonstrated but not utilized.
Not utilized, my lord. That's the my lord, movement. It is now, my lord, after the VAT, they have utilized it.
Hmm.
The question of particular.
But that order has to be
Now,
passed
my
by
lord,
the GST authorities.
my lord.
Okay,
How
fine.
can you carry forward it?
Okay, let us say that he has carried forward it,
That my lord is not entitled.
carried forward illegally. Let us. But there is a process for that.
Now, my lord, only thing.
You have 14.9, no, 14.9. 14.9 you have D, which again is the provision.
140.
No. Under the 114.9D, where excess input credit has been claimed. Now the reversal can be under that provision. You have not reversed it at that. Now this is by the VAT authorities notice, and it is under the 2003 Act.
Yes, that's why, my lord, the entire issue now boils down to, my lord. But, my lord,
No, first point is jurisdiction.
Yeah,
Jurisdiction.
all can, my lord, initiate proceeding.
VAT or it should be by the GST authority.
It is a GST will prevail. My lord, that.
Okay.
Otherwise, my lord, the issue is, my lord.
Only thing is, the first question is jurisdiction. Admittedly, he was not entitled to that amount, but whether at this stage, after the repeal of the 2003 Act, you could have invoked that same to do this. If you can do it, you are well within your rights.
There is a
Otherwise, my lord, Lordship will give the liberty that if at all there is some problem.
That liberty would be a. It's already time, but
We can clarify one thing. It appears from that credit was not available.
no, he's making his assumption, sir.
I'm not saying it all, I
No,
never
no.
say. I'm saying that from the papers and briefs, it appears that this input tax credit, he was not entitled to. Maybe under wrong misconception. But the fact remains that on 36, this input tax credit was there and not utilized for payment of any VAT amount. If this amount was not utilized for payment of any VAT, the question of recovery of the amount does not arise because no payment was made for VAT. Now, this was carried forward as per this GST law for the next year, because the whatever the input tax credit remains, it has the GST law. One and all we did has to be carried forward. Was carried forward. And this was utilized for payment of the GST amount. Now, what was on a paid or less paid utilized is the GST,
Not the VAT.
not the VAT. So action any if under the law for either reversal or for recovery of the amount
Will be under GST Act.
under the GST law only. Whatever may be, whatever provision you think fit.
This is for the period April 2017 to June 2017. You have utilized this amount?
My lord is not in after 1/7/2017.
1/7/2000.
17.
So your return is after
But
1/7/2017.
this is 36/2017, the amount was lying.
No, fine, I got it. This was that tax demand was what that was there. Was it for a period prior to 36
No,
to
Lord, this is
prior
not-
to?
He's saying that you have utilized because subsequent after the GST, the VAT authority cannot be issuing notice.
No, I'm not. Just for my understanding.
I know.
Just to get the facts.
I
correct. This amount that is there, 24 lakhs odd, was a demand under the was a claim under or was a assessed due under the VAT Act,
VAT Act. You
under the VAT Act.
You lost me. Just see 1 second, Lord. Even for the sake of repetition, In the heading itself, my lord.
Hmm.
Under the VAT Act, period, your lordship may see.
Page
Page
1/4/2017 to 36/2017.
prior to the GST.
No. This is amount ITC is prior to GST. There is no doubt. The utilization was for a claim under the VAT Act,
GST law.
under the GST law.
There is no question of the VAT, because on 36/2017, the VAT has gone.
So, Mr. Just for my
Fine.
understanding, I'm not being getting this. Okay, 36/2017, the VAT Act goes. But the financial year started from April 2017 to
After this coming into force of the GST Act, this was only 3 months was under the VAT law.
so this VAT law, 3 months. I'm not that only.
My lord.
This 3 months, the returns have to be filed under GST or under
3
VAT.
months Under the VAT law, up to 36/2017 VAT law.
VAT law. So if it is under this amount that you have utilized, is so utilized for meeting the demand of the VAT law?
No.
That is what I'm trying to get. How do you say that this is for GST?
Whatever 36/2017, whatever payment is to be made under the VAT law, it has been paid.
It has already been paid.
There is no demand.
So this utilization that you have projected in your return
My lord.
of 24 lakhs is not in satisfaction of a VAT demand.
No.
Sure.
Yes.
Where do I get that?
I have to find out, my lord. If that is so, my lord, then there is no dispute.
Because if you come to your reply
My
at
lord.
page 23,
My lord.
this is your current, 36 is your current,
My lord.
being brought forward from March 2017, 82, credit for taxes charged by so-and-so, so-and-so, so-and-so. So total is 24 lakhs odd.
My lord.
Less output tax on sales during June 2017, 571. Net input tax 36. So this is the net you have there.
My lord. The last paragraph, if your lordship just looks into
Ah.
that 10, my lord.
Uh,
The adjustment of the input tax.
okay, this can only be in GST, not in.
Not under the VAT.
So, Mr. Gogoi, this amount is not utilized for satisfaction of your dues. This is carried forward. It was there. And till he utilizes that amount, you cannot take any claim therein. He put it. Mr. Saraf, this is a provision made in your tax returns for the last around 12, 13 years you have been making it.
No action was taken for earlier.
You having not utilized it, the respondents, the taxation VAT would not have any occasion to question that. Because you have been paying your assessed dues.
He could have reversed
Okay, fine.
earlier.
You would have reversed. Now, when the GST has come and you are utilizing this amount for satisfaction of their dues, GST dues, and they find that this amount is not liable to be received by you, what is the way out?
Issue notice to me for
GST authorities to issue notice to you and then take a call on that.
374.
That will follow, subject to limitation.
I can fully admit, my lord,
This should have been disposed of on the first day itself.
that I am on a
No, you are not on a weak footing, Mr. Saraf. You are on a very strong footing.
weak footing on the facts, my lord. But
On the law, you are on a very strong
the
footing.
question is only the applicability of the law.
Law. And if the law is applied, you go scot
That's why
free.
I submitted for lordship, my lord. Lordship will give a liberty to them.
That liberty is a nullity.
Whatever they have not, if any provision.
Now, Mr. Saraf, as a officer of this court, in such situation, what is the way out to the revenue?
To the revenue.
Revenue.
But in these situations, the only option with the revenue is to close the file. Of 50 crores, my lord, where the assessment was not done and reassessment was done,
36.
the court set aside.
So this is tax law. It should be interpreted very strictly.
Lordship knows, my lord, that
I don't know. I'm learning from you.
the court says, my lord, the court can iron out the creases but cannot alter the materials of which the cloth is woven. That is not
Can
permissible.
you just give me a copy of that ITR?
Will give.
107.
That has already been given, my lord, in the income tax case, your lordship.
Earlier one. That's why I remember that.
That one has already been given. Interpretation of statutes also been given.
Given. That file, I unfortunately am not carrying.
Give it again.
Just give me a copy.
But that is settled law, my lord, that, my lord, in fact, in one of the cases, the court said that it may be so that the interpretation which we are giving give a loophole from which the SSC can pass.
But he will have
But
to be
our
permitted.
hands are tight. It is for the legislature to take action of the loophole.
Okay. Mr. Gogoi,
But the same thing should apply to SSC.
if it was the SSC, you would have been taken to the
Today, tomorrow,
cleaners.
they could have money, jump on and attach my bank accounts. But
Everything.
it has to be, that's why the Supreme Court said there is no equity.
Equity in tax law. That one judgment I have read about that. Okay, 2 p.m. You need not be here. He is only clarification I'm taking.
In other court, my lord, I will be there.
Huh?
I'm not in other court. I will certainly be there, my lord. Why not? Highly obliged.
Thank you.
There is an order on 29/12/2024 that, my lord, the action plan for the year 21 to 24 is subject to the outcome of petition. My instruction is that, my lord, in the meantime, they have submitted one instruction on the last occasion to the effect that the works were completed. My instruction is that entire exercise was carried out in violation of the provision of the Assam Panchayat Act, and no work was there.
Okay.
So I'll
Like,
file affidavit.
JMH, no, you don't file affidavit. If they have violated the provisions of law,
Yes.
you take up the actual course of action required, file complaints, file FIRs.
No, my lord, my submission is that.
Your writ petition, we are closing it because they have given this. If they have not carried out in the manner required, you initiate the process of law.
Submission was that, my lord, on that premises, my lord.
You are nothing. They have done it. You have gone.
No, my
And
lord.
if they have not done it in the, your cases 2021, 21, 22, 23, 24 implement. They have implemented. We are not going to see whether it was implemented in manner A or manner B. It was implemented. Mr. J.M. Chaudhary, if there is something more, institute a criminal
Okay,
proceeding.
my submission is that, my lord. What my submission is.
I'll
that-
record your submission.
Yes, my lord. My submission is that, my lord, the action plan, this amount was, my lord, pending with the Gaon Panchayat, and I am the president of the Gaon Panchayat.
You were.
You were.
Hmm.
Yes, my lord. And during that period, by operation of the law, my lord, Gaon Panchayat hold the Gaon Sabha and submitted the action plan in terms of the provision of the.
Mr. Chaudhary, if the thing has not been done in the manner required,
Yes.
you go and institute appropriate proceeding. We'll give you liberty to that. Before the police. Let the law take its own course.
And if the authorities, my lord,
So now
if-
the
if
question,
authority- If the authorities has violated the provision of the Panchayat
They,
Act,
you institute proceedings against them, they'll face the music. Mr. Chaudhary, your writ petition was to the effect that 2021, 22, 21, 22, 23, 24, these schemes were not executed. That was your,
in terms of the action plan.
but that is a different thing. That is always in terms of an action plan. It has not been done. Now, the materials brought on accord by the authorities reveal that they have executed that. You also cannot say that the money that was there was not put to use. It was put to use. Your case is that that is paper expenditure or works not in accordance with the work set out. That's a
That's my
criminal case. You go and institute a proceeding.
Day one, my case is that the action plan which was submitted by the Gaon Panchayat.
Action plan that your case is because the money was not forthcoming. So the action plan remained.
They have modified it.
If that is
Without
not
authority,
permissible
ma'am.
under law, you go ahead.
They have modified it.
You
without
go ahead.
There being any authority.
You
ma'am.
go ahead. Institute a proceeding before the institute a criminal
Because-
proceeding against them.
I've brought on record.
It's
that
corruption.
MLA has given a note.
Mr. It's corruption.
Yes.
Corruption, there is a criminal system in place to take care of that.
But authority should act in accordance with law, my lord.
They will.
That-
They will. If not, you make them act. This is not for this court to find out. But tell me, how
That
will
liberty
I?
may be granted, my
Huh?
lord. I'll approach the authority.
Yes. I'm not saying correctly. Why have you not implemented it in the earlier manner? Everything. Okay. Heard Mr. J.M.H. Chaudhary, Learned Counsel for the petitioner. Also, Mr. Sharma, you are appearing, also Mr. S. Dr. Learned, Standing Counsel, Panchayat and Rural Development Department, appearing for the respondent number 1 and 2. 1, 2, 4, 5, and 6. Mr. H. Sharma, Learned, Additional Senior Government Advocate, appears for the respondent number 3. The grievance raised in the present proceeding pertains to the inaction on the part of the respondent authorities in implementing the action plan / development plan for the year to 2020-21, 2021-22 and 22-23 and 22-23 and 23-24 for the Sargola Gaon Panchayat. Also, the petitioner in the present proceeding was the erstwhile president of the said Gaon Panchayat. Also, the further grievance of the petitioner is that the development plan for the above noted financial years is required to be implemented strictly in accordance with the action plan submitted in the matter by the Sargola Gaon Panchayat after the approval for the schemes included were so received from the respective Gram Sabhas. Also, the petitioners had initially filed an affidavit wherein they had contended
I think page 56.
that the respondent authorities had not approved the action plans as submitted initially for the year 2021-22 and 23-24. And the secretary, Sargola Gaon Panchayat, had again submitted the action plan for the years involved with the approval of the Gaon Sabha on 4/6/2024. Also, it is further submitted by the respondents that the action plan submitted was strictly in accordance with the guidelines holding the field in the matter. Also, during the course of the hearing of the present matter, this court having required the District Commissioner Sri Bhumi to place on record the status of implementation of the action plans for the years involved, the jurisdictional district commissioner had via communication dated 13/8/2024 placed before this court the fact that the action plans as approved were executed by the Sargola Gaon Panchayat for the years 2021- for the financial years 2021-2022, 2022-2023, and 2023-2024. Also, the communication dated 13/8/2025, along with the enclosures thereto, were directed to be furnished to Mr. J.M.H. Chaudhary, Learned Counsel for the petitioner, and the matter was fixed today for further consideration. Also, Mr. J.M.H. Chaudhary, Learned Counsel for the petitioner, has submitted that the schemes which have been now projected to have been executed for the financial years involved are the schemes are modified schemes, and such modification of the schemes was so done without approval of the Gaon Sabha. The said contention is disputed by Mr. S. Dr. Learned Counsel for the Learned Standing Counsel, PNRD Department, who submits that the schemes which have been executed during the financial years in question are the schemes which had the approval of the Gaon Sabha, and the said position is also reflected in the affidavit filed by the respondents. Full stop. The materials, the rival claims of the parties to the proceeding bring to the forefront that the grants as received from the 15th Pay Finance Commission, both tied and untied, for the years involved were utilized for implementation of various schemes in the Sargola Gaon Panchayat jurisdiction. Also, in the event it is the case of the petitioner that the schemes have not been utilized in the manner required by utilized by following the procedure mandated for the same, comma, the petitioner is to invoke the criminal jurisdiction for criminal jurisdiction against the misuse of powers by the authorities empowered to implement schemes as per the grants made by the 15th Finance Commission. This court, in the present proceeding, it having been brought to the notice of this court that the schemes involved and schemes executed for the financial years involved out of the grant received by the Sargola Gaon Panchayat from the 15th Finance Commission recommendation, pursuant to the recommendations of the 15th Finance Commission, being the schemes which had the approval of the Gaon Panchayat and no concrete material being made available on record disputing the same position, this court would not be in a position to adjudicate upon such disputed questions of law by way of affidavits filed by the parties. Full stop. Accordingly, the present writ petition stands closed, noticing the implementation projected to have been made in the implementation of schemes projected to have been made in Sargola Gaon Panchayat, comma, which is again stated to be the schemes prepared, schemes approved with the schemes prepared and approved by the Gaon Sabha concerned. Full stop. In the event there is any lacuna in the implementation, in the preparation and implementation of the schemes, liberty is granted to the petitioner to institute appropriate proceedings with regard to the same against the persons who are responsible for such diversion of funds involved. Full stop. With the above observations and directions, the present writ petition stands disposed of.
Obliged.
You go and institute. You want a liberty also?
Yes, that is done. Only criminal and civil may be, Malab. If the departmental authority, then it will be civil, Malab.
That is up to you. You go and take appropriate action. Proceedings, both criminal as well as departmental. I'll make a line for that. Yes, Mr. Sama, have you got the report?
If was sent by special messenger, Lordship, the original record. Lordship, which is not in. I told them to. So
Mr. H.
I'm
Sharma,
for
Learned Additional Senior Government Advocate submits that the report as called for was forwarded from the office of the
Deputy Commissioner Nagaon.
Deputy Commissioner Nagaon, District Commissioner Nagaon. However, the same is yet to be received by him. Also, he submits that the matter be taken up again on
Next week, Lordship, anything.
next week would be difficult. 5/9/2025. Also, Mr. Sharma, on the next date of listing, shall place before this court the report concerned in terms of the directions passed by this court in the present proceedings wide order dated 28/7/2025.
Well, your Lordship has directed us to obtain the instructions.
Who
which
is the authority?
This is the notification. District. District and Session Judge, Lordship.
Civil court. That concept of principal civil court is in under the NHI.
I understand that, but my lord, because this is district and session judge cannot be, my lord, session judge cannot take up this matter.
Land Acquisition, Rehabilitation and Resettlement Authority within their respective jurisdiction 51.
Similar. Invest.
My Lord Justice Medhi's order. For that. Oh, this is quoted here. Yes, Mr. Padre.
I think, my lord, I will approach within a particular period, and till then the interim order will continue. My lord.
Heard Mr. P.K. Roy Chaudhary, learned counsel for the petitioner. Also heard Mr. A. Vatsaja, learned standing counsel, Revenue and Disaster Management Department, appearing for the respondent number 1. M. Rahman, respondent number 5. Who is there for BTR or PWD? Mr. H. Sharma, learned additional senior government advocate, appears for the respondent number 3 and 4. None has entered appearance for the respondent number 2, and Mr. M. Rahman, learned, itu last lihi none has appeared. Mr. M. Rahman, learned counsel, appears for the respondent number 5. The grievance raised in the present proceedings by the petitioners is for a direction upon the respondent authorities, more particularly the respondent number 3, to disburse the assessed compensation for the land acquired equally along with respondent number 5. Also, the facts, they put full stop. As projected in the writ petition, the writ petitioners, 5 in number, contend that they are the sons of late Noor Hussain. Also, late Noor Hussain, along with the respondent number 5, jointly acquired a title in respect of land covered by DAG number 646/1157 under Patta number 184 of village Fondikor, Moza, Kaurbaha under Goreso Revenue Circle, District Tamulpur. From 1 Musammat MUSTT Neela Musalmani by way of a registered gift deed on 17/5/1980. Also, Noor Hussain, having passed on, his has, that is the petitioners herein, got their respective names mutated in the land records. Also, accordingly, the petitioners now claim that they, along with the respondent number 5, are the joint pattadas of the plot of land covered by DAG number 646,1157, under patta number 184. Also, subpara. The respondent authorities in the year 2023 acquired the land of which the petitioners and the respondent number 5 are joint pattadas for apostrophe improvement and upgradation of road, comma, from Rongia Kaurbaha to Nagrizuli Road under the Assam Mala project. Also, thereafter, the due compensation for the land of the petitioners as well as the respondent number 5 so acquired was computed along with the Zirat compensation payable. Also, however, in the statement so prepared for disbursement of the amount of compensation assessed, comma, the petitioners found that the land covered by DAG number 1157 has been shown in two parts, that is, 1 kotha of land to be under possession of Nuruddin Ahmed and 2 lessa of land to be under possession of the petitioner number 4 herein. On the basis of the said possession of land, the compensation has been calculated, and accordingly, the Nuruddin is respond number 5 was shown to be entitled to receive an amount of rupees 12,90,531,58 words or likhidima, and the petition number 4 was shown to receive an amount of 45,000. The names of the other petitioners, however, did not figure in the said list so prepared. The representation submitted by the petitioners having not received its due consideration, the petitioners had instituted the present proceedings. So, this court, wide order dated 2011-2024, noticing the submissions made by the petitioners to in the present proceedings, as well as the fact that the land continued to be jointly possessed by them along with the respondent number 5, comma, was pleased to pass an interim direction to the effect that the amount of compensation, if not disbursed, comma, the same shall not be disbursed until the next date fixed. The said interim order continues to hold the field as on date. Also, the learned counsel for the parties submit that the land involved has been acquired under the provisions of the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013. Also, while the respondent number 5 submits that the land in question has been partitioned in pursuance to a family settlement, which was so initiated by the petitioner number 1 herein, comma, the said position is disputed by the learned counsel for the petitioners. Also, a dispute having arisen in the matter, comma, the amount in question being kept, amount of compensation determined being kept in abeyance by this court, comma, the counsel for having been kept in abeyance by this court, the learned counsel for the parties have submitted that they be permitted to take a recourse to the provisions of Section 76 of the said Act of 2013. 76 read with Section 51 of the Act of 2013. Also, 2013 Act. 2013 Act. Right to fair compensation. Let me take this. That's it. If I don't get it from here, it will be a problem for me. So I want it from here only. Also, provisions of section 76 pertains to a dispute as regards apportionment when the amount of compensation has been settled. Also, the dispute covered by sections 76 pertains to only a dispute arising from a dispute related to apportionment of the compensation or any part thereof, or as to the persons to whom the same or any part thereof is payable. Also, under such circumstances, it is provided that the collector may refer the dispute to the authority. Also, the authority, that is, authority to whom the dispute would be mandated to be referred is the authority as contemplated under the provisions of section 51 of the Act of 2013. That is, the Land Acquisition, Rehabilitation, first letters down, and Resettlement Authority. Also, the respondents in the Revenue and Disaster Management Department, wide notification dated 27/5/2020, had constituted the authority to decide disputes under section 76 of the 2013 Act. A perusal of the said notification dated 27/5/2020 reveals that the Court of the District and Session Judges of the districts of Kamrup (Metro), Nagaon, Sonitpur, Jorhat, and Kachar. It reveals that the courts of district and session judges of the districts of Kamrup Metro, Nagaon, Sonitpur, Jorhat, and Kachar shall continue to act as the Land Acquisition, Rehabilitation, and Resettlement Authority. And the said courts will act as the authority for the respective revenue divisions, viz. Lower Assam, Central Assam, North Assam, Upper Assam, and Barak Valley divisions respectively till further orders. Also, in view of the dispute arising in the present proceeding and the same being relatable to a dispute pertaining to apportionment of the compensation amount between the petitioners and the respondent number 5, relatable to the provisions of section 76 of the Act of 2013, this court is of the considered view that the matter would be required to be referred to the authority as contemplated under the provisions of section 76 read with section 51 of the Act of 2013, along with the notification dated 27/5/2020. Also, in view of the above position, the petitioners as well as the respondent number 5 is directed to approach the collector. Collector will do collector within a period of 15 days from today with an application praying for reference of the issue to the authority under section 76 of the Act of 2013. The collector on receipt of such application shall refer the dispute to the authority as contemplated, as empowered, wide notification dated 27/5/2020. Also, the authority on receipt of the reference made in the matter from the jurisdictional collector shall adjudicate thereupon and pass its orders within a period of 3 months thereafter. 3 months from the date of receipt of such a reference by it. Also, till the decision of the authority is so received and the manner of apportionment of the compensation amount is determined, the amount of compensation assessed with regard to the acquisition of the land of the petitioners, claimed by the petitioners and the respondent number 5, shall not be disbursed to either of them by the collector. So the disbursement of the compensation amount shall be done in accordance with the decision of the authority. That would now eviction is what? Nobody is evicting you. Who is evicting you? Oh, land acquire eviction, there is no right. You will be evicted. Your money you are fighting, government is ready. Both of you will be evicted. There is no equity here. What right do you have to continue? You are getting a compensation. Compensation is already assessed. You are not receiving it because of your dispute. Left. Okay. Authority. Full stop. With the above observations and directions, the writ petition stands disposed of. Mr. S. Bora, Learned Standing Counsel, BTC appears for respond number 2. Uporota. Done.
My lord. For your lordship, Rajesh, my lord.
No, I'm not rising. Something is there, madam. Please be.
I may be permitted to mention item number 31, my lord.
No adjournment, other than adjournment, madam, anything.
My prayer is, I pray for to withdraw the matter, my lord, with a liberty to file afresh.
This matter will not permit you to reopen, madam. Honors Act. The agreement from Calcutta, the very reference is agreement arrived at by Calcutta party with the TX state. Ma'am, we will not permit you to withdraw it with liberty. We don't want this matter to be coming back. Because there is nothing on record.
I have a chance, my lord. Some liberty, if possible, my lord. I will try my luck.
What liberty can I give? It's up to the tea gardens and their employees to come to a conclusion. Some tea gardens have done it. So you have made them pro forma respondents. But with regard to the others, how can we? That would be raking up an old issue, man. It cannot be.
I understand, my lord. But
What liberty can I give you?
liberty, my lord, to file afresh before the Labour Commissioner, my lord.
On this issue, 2007 issue. Sorry. You satisfy me that you have a right to do that. A reference is done. Closed. How can we now, without interfering with the reference, without interfering with the award, how can we revive the reference? Or the issue involvement? We'll hear it, we'll pass orders.
For that, my lord, I do not want to go on merit, my lord. So I will withdraw the.
Okay, you withdraw it per se, simple, we have no objection. Miss MS A. Bhattacharya on instructions submit that the petitioners wish not to press with the matter any further. So accordingly, she prays that she be permitted to withdraw the present writ petition. Mr. M. Nath, Learned Senior and senior counsel appearing for
1 and 15.
respondents number 1 and 15 submits that he has got no objection to the prayer made by the learned counsel for the petitioner. Also, in view of the above position, the present writ petition stands dismissed on withdrawal. Madam, you can always go for a conciliation between a garden concerned, because madam, if the garden is to give you an ex gratia, you will have to demonstrate that they had a surplus fund. The Bonus Act does not give you that liberty. You go ahead, you do. If they don't do, go for a conciliation, get a reference done, but it will be garden specific. Am I wrong in saying so, mister? You don't look to be very happy.
I don't get the audacity to say, my lord. Lordship is wrong, that audacity.
No, audacity as a senior counsel you always have to guide a court to be in the correct path.
Senior with the lordship's understanding, my lord. It has got nothing to do, my lord.
That is not from Mr. Nutt. Okay. What is that? GST Act. One 24. One?
One 174, one says, my lord, regarding tax and the amendment of the finance shall not affect any investigation aspect of any such tax surcharge, right, privilege, obligation, and any such investigation or remedy may be continued here or enforced, and any tax surcharge penalty have not been so amended.
Mr. Gugui, to answer this, to accept this, no, not the authority. Factually, the contention of Dr. Saraf is that he has not utilized this amount during your regime of 2003. So at best, you can only go for a reversal under that act. You have not gone for a reversal. Rather, you have imposed a tax when that tax was never a claim by you. The claim is if that input tax credit is said to be not permissible, should not have been, you could have gone for a reversal, but you could not have passed that order. The first part of your that notice is fine, maybe, but the second part is not, because the claim which he is trying to now fulfill, the dues, is under the GST regime, not under the VAT. That's, Dr. Saraf, that's your case. What do you say?
Only on this point.
I don't understand much, but when stalwarts are there, you get to, something goes inside. Very hard-headed, but something goes inside.
Whether it
This provision may not have any application to your issue. So the amount was there, you could have gone for reversal. I was having a view that he had utilized this amount for meeting the VAT taxes, so that amount, because it's not permissible, so a demand was made. But today when Dr. Saraf was arguing the matter, I come to what he's done is you have taken that amount and you have imposed a penalty on that. That cannot be because it was never utilized in your regime. It was under the GST regime only. Okay, fine, no issue. Heard Mr. Dr. A.K. Saraf, Learned Counsel for the petitioner, assisted by Mr. P.K. Bora, Learned Counsel, appearing for the petitioner. Also heard Mr. B. Gugoi, Learned Additional Advocate General, appearing for the state respondents. Also, the parties have been heard at length. However, Mr. Gugoi submits that he be granted a day's time, granted some time to place on record certain to place on record authorities in some purport of the submissions made by him. Also, prayer accepted, a registry to list this matter again on. Dr. Saab, you are here next week. এই দুটাই সৰু বস্তু বেছি টাইম নালাগে 2/9/2025 for further hearing.
74 will not be.
I'll be happy, but on the plain reading of that, it is clear that it is not applicable.
Finally, Milord, the VAT Act, the assessment order was passed in 2022.
22.
It was the assessment order.
Uh,
I don't know how the assessment order under 2022, when the assessment was passed, there is no assessment order, there is no notice for assessment order.
no, it was a notice for reversal.
So
and-
there is no assessment order, although he has mentioned it in the assessment order.
Hmm.
That it is an assessment order.
Assessment, it cannot be.
It cannot be.
36.
Now, Your Lordship may kindly remember, my lord, the maximum time limit under the VAT Act is 5 years.
5 years.
From the
42,
end-
it is 8 years.
What?
42, section 42.
40,
40.
40 when some assessment is there and it has
Escape.
escaped assessment. Now, assessment can only be when some liability is tax has been assessed.
Huh.
8 years, even if assuming it is counted, then also the assessment has to be there.
Ah.
Now, there was no assessment in this
Ah.
case. Now, my lord, 5 years have already passed. This order, my humble submission, perhaps subject to your lordships, whatever will come, this order
Cannot.
stand the scrutiny of law. Now, if this order cannot stand the scrutiny of law, all other actions
Gone.
which were not there prior to, because GST never says that you forget about the limitations of the VAT Act. The limitations will remain. Whatever limitations are there under the VAT Act will remain. So even if assuming for the argument's sake, because I have already taken the credit under the GST law, now they cannot reverse it because that has also become part of my limitation.
Hmm.
Assuming they reverse it today,
Hmm.
assuming under the VAT law, they say that I will reverse the input tax credit. There will no effect.
Hmm.
There will no effect because the tax which was utilized for payment of the GST, that has been done.
Accepted.
That has
Dusted
been
and closed.
accepted. Now, if 2018 it has been done, maximum time limit is 5 years from the end of the financial year. Now, that is 2023, everything is closed.
Hmm.
Whether my learned friend wants to reverse it or not reverse it, there will be no effect
Effect.
at all because every time limit has gone. And once the GST has come and it has been utilized for payment of GST, the question of the VAT
Coming in.
does not arise.
Because 174 is also, the D is preceded by certain conditions. Affect any investigation, inquiry, verification, including scrutiny and audit, assessment proceedings, adjudication.
Which one it falls, my lord?
Reversal will not fall in any of
Which
this.
investigation, under which provision?
Any other legal procedure for recovery of arrears?
Where is the recovery?
For that, you will have to have a reversal first.
The recovery where from come, my lord? There is no recovery. It has
Under
been
VAT,
utilized.
under VAT, there is no recovery. And that is why maybe the order, it says input tax excess credit claimed interest on that. He has never utilized that amount for you in satisfaction of your dues.
There is not a single provision, my lord. I must submit to the best of my understanding, my lord. Because any action under the act for the recovery of the amount can be taken only when somebody has taken excess input tax credit, that means utilized it, or, my lord, he has not paid the tax, availed and utilized, the Patna High Court has observed, my lord, it is only when it has been used for reducing the tax liability,
Then only that amount can be
it can be said to be, my lord, availed and utilized. Now, I have not
availed
utilized that amount for reduction of the tax liability during
under
the VAT
VAT.
period. Thereby, how the action can be taken under the VAT period? The only thing was that reversal they could have done.
Huh.
Now, the reversal also,
Gone.
that has also gone because that action also, by no stretch of imagination under the limitation period, it will survive. 17 to 2028, we are 25, we are there. That is also not there. Assuming, for the argument's sake, my lord, assuming that they have the power to reverse. Assuming, my lord, for the argument's sake, that they have the power to reverse. Today, they reverse it. The SSC is not going to be affected in any way because it has already been utilized for the GST payment, and that was after that 5 years limitation has gone.
Gone.
And that is 5 years is only for suppression. Here there is no suppression because everything was there.
There in your returns.
Returns. So section
So
73.
they had the power to reverse in 2017 itself, or even before that, minus that 82,000 which came in subsequently. But they had, while initiating this process, widely notice, utilizing 14(9)(d), they had moved in that direction. But subsequently, when they passed the assessment, they termed it as an assessment order. Let us take it as an assessment order only. Therein, they made a mistake by drawing that this amount is subject
Assuming,
to.
my lord, we take it. And the notice is correct, but the order is wrong. Petition says the assessment order must be made,
Within 5 years from
not notice issued. Initiation.
assessment order.
It must be made within 5 years.
Uh-huh.
Now, if it goes, then the question of passing the fresh assessment order after 7 years does
Will
not
not.
arise.
That one case, you were there or you were there? 36, 39 was brought. That
Certain
it was
cases-
that case of
So Lordship passed the order that.
Chocos notice. You said
Everything will.
you have said that you are going, but so Dr. Saraf's argument was in line with 36.
40
What
will-
is reassessment? And you say section 9 of the section 9.
2 of the Milot. There the question was that Milot, the reasons to believe that the turnover has accept assessment. That finding there was nothing, and simply on the basis of
They wanted to do a reassessment.
while completing the assessment, they mentioned it 40. Certain cases, Milot, there is no way out.
Well, can't help it. This was the only logical query that I was asking, which I asked you in the morning. After that, let Mr.
Yes,
Let him have
we
his
should
satisfaction.
always place, I never object. If anything is there, we will also learn.
Not for you, but for my
No, I will.
learning.
Our side also, Milot, we will try to learn, Milot. The interpretation of taxing statute judgment, shall I give?
No, give it me on that day. I would love to have it with introduction from your end.
I'm highly obliged, Milot.
Mr. Saraf, this is something which I am picking up now only.
Of judgments of lordship has come.
No. But still, once
That is
the
the great
foundation is not there, it's
That's
very
the very
difficult.
case when somebody says that I don't know, then it is taken Milot that he knows everything.
No. This is a very, what do you call it, bona fide thing.
Is it
Thank
right?
you. Thank you.
Fine.
When was it notified, Mr. Borua? Till date. Notification, was it published in the Gazette?
No, it hasn't been published in the Gazette.
Sure.
Yes.
My lord. That was, my lord, notification that was there. There's a submission made by the government of Assam also, my lord, in another writ petition. My lord,
This is done by which department?
minor and minors. Religion minor.
This is with regard to that forest mining.
Forest mining, my lord, stone quarry, stone that is a forest product that is decided. Try to get the notification, but notification that is there, my lord, that.
You have that, you had that copy. Can you just give it to me for a second?
My lord. That
No problem.
headlighting head note person was my lord earlier advocate, my lord, Mr. was there. This is his handwriting, my lord.
Who has made this rules? Which department?
This is a power conference if you Assam section 20 Assam. It is an exercise of power under section 54 of the subsection
Okay,
2.
54 is by the government. But which department of the
Prevention,
government?
Control and Demand Act 1981. Government
Which
of Assam.
department of the government had done it? So they'll know whether it is published or not. Because it says that will come into effect from the date of publication in the Gazette. So only a Gazette publication is required.
Department. The Forest Department may be the. I have also reconfirmed. That draft regulation, the pollution board has included in its website only for the guidance of the officials.
But
So
in-
that we may be guided before giving a consent to any of the.
But it is here, it has been submitted that the government of Assam has notified the so and so, so and so. And there is a judgment of this court wherein this.
Also have orders whereby strict clean establishment.
It's not been gazetted.
But in many of the cases, they have stated that.
Because notification of these regulations will naturally have a bearing in the present case.
But here.
2-1.
But here we are only guided by the conditions precedents. And subsequently the consent to.
Now, what is your material that how did you arrive at that satisfaction with regard to issues?
For that matter, also tag those phases.
You can tell me from there.
Yeah.
Hmm.
And air quality monitoring has
When?
on 25/11/2000.
That will also not satisfy because the consent of operate was given on October. Telling you, before October, when you issued that consent to operate, whether the consent to establish conditions were satisfied, at least with regard to establishment of the requisite machines and all those things,
Yes.
that satisfaction, how did you
That
draw?
satisfaction for the consent to operate, which has been granted on 8/10.
Hmm.
So along with that, an appendix A has been added.
Hmm.
So whereby all these conditions, the parameters which they have to follow before.
No, I am with the last paragraph of 810. 8-9, sorry. 21-8, no, 17-9. The last paragraph of 17, sorry, 8-9. 8-9, last paragraph of 8-9.
Stone crushers are allowed to while granting consent to establish and ensure proper system to arrest air and sound pollution said.
This is what I want to do.
Yes, that's what I'm trying to.
So where is that establishment of those systems satisfaction with regard to them? Your ambient quality thing will come.
It will come after it
He
has come in
operates.
operation, yes.
But before that, these systems were put in, where is that?
System in the sense, there is no big system. But it has to be.
It will not be
navigated.
green covered in a day.
That's what we have photographs to substantiate. So,
Where is that system that he has installed a system for maintenance of, what do you call that, air quality, for maintenance of sound? You give me that satisfaction with regard to.
Satisfaction obviously has to happen with the officials, only then the consent can be granted. Otherwise.
No, show me how you have drawn it. You have drawn it. It cannot be in air. There is something in your records which says, okay, this man has fulfilled the conditions given.
That's what I'm trying to.
But it should be before that date. Now, December, sorry,
I'm talking
October.
about 8/10.
8-10.
Yes. The 8/10 includes an appendix whereby the conditions which are marked in the consent to establish obeyed. And since they have gone into those conditions, the consent to operate has been granted. This is that whereby the petitioner has been granted to operate. So these are the conditions which are already there in the consent to operate. Established. I'm so sorry. Quantitative standards for suspended particulate matter. Suspended particulate.
Mr. Borua, this is appended to the consent to operate.
Yes.
I am on the consent to establish. The last paragraph of consent to establish. You come to page order dated 8/9/2024. 2014, sorry. 8/9/2014. That is the consent reaffirmation of the consent to operate. Now you come to the last paragraph thereof.
Wait, I can't do it.
Page 42,
Reaffirming.
internal page 42 of the affidavit of Mr. Hazarika.
Yes. How to establish a strict court while granting the consent to establish to arrest air and sound pollutions.
Okay, then you come to your 810. So this is something which you are now stipulating that he will have to follow when he is operating the stone crusher, right? Now, before issuing this 810, what is the material available on record that he had satisfied the stipulation made in last paragraph of 8(9)?
Is for that matter, that inspection report was
Inspection report when?
18/9/2000.
18(9). What is that report?
In between 8/9.
What is that? What does that inspection report say?
Side of the Messrs. Amguri
Hmm.
of the unit.
Hmm.
Product name, raw materials, fuel size, GPS data, so and so location. It is located at by the site of Dudar Ali, surrounded by site. Then pollution aspect. Air. The unit being a stone crusher, it will generate dust and noise in regard to dust. The owner of the unit has covered the boundary with HDPE sheet of about 15 feet height. The unit will also make arrangement for water spray system also to noise. The crusher has been installed at ground level itself. Then second, as regard water, there shall be no discharge of wastewater purpose to control present status. The
Noise,
crusher
what
use
about
has
noise? What does it say about noise?
As regard noise, it cannot report on that particular point of.
Okay. So it is, in the report, it is that it is within a residential area.
It doesn't say.
It doesn't say. What does it say?
Not vacant land and house of one Dimbeswar Gogoi hasn't been mentioned. Paddy field on the south, east Dhudar Ali, west paddy field. So these are the parameters of the west, north, south.
Then basing on that, you had.
And also the site inspection report.
Where is the photograph? So where is your that HDPC barrier that he is stated to have erected? HDPE is some plastic sort of a material.
I think.
Boundary wall type. There is no boundary, it's all open. A green net. The net will not do it because the net itself seems to be only for a purpose of show. Okay, thereafter what happened? You then, after he started operating, you made inspections, further inspections. Okay, that you have brought on record by way of a affidavit, right? Can we go can you take us to that?
May 2000.
25 May 16. You have a report of 25/11 also. Where is that?
Those were not included in my.
Where is that?
That is here.
The record. What does it say?
25/11/2014. Consent to operate has been granted the
Next month.
previous month. Previous month. Next month, ambient air by one authorized agency, that is Aerocon. So here the limit has been approximately 12 meters distance. Particular matters has been enumerated.
Okay, then you did a further thing on 2016.
Time to time.
Okay, now let's come to that. 170. So it should comply both with air ambient quality as well as sound. Now you come to your, that report, which is a part of your affidavit. Affidavit dated 23/6/2016, one by one Mr. Gokul Bhuya. It is 27/5/2016.
Yes, 27.
And do you know the fault in this report? You come to which page 171, internal page 6 of that report. You have got it?
Internal page.
Internal page 6. No, no, no. It's an affidavit by one Gokul Bhuya. Dated 23/6/2016. The report dated 27/5/2016. Mr. Mahanta will have it.
The affidavit dated 22/6/2016.
Page, internal page 6.
Internal page, my lord.
6.
6 is the report.
Just give it to Mr.
Internal page 6 and 7, my lord.
Got it? So this, if you can come, 17/5, 17/5. Come to the next, 27/5. Can come to the next page. It is 27/5/2016. Ambient air quality, right? Naturally, it is 600 is the limit microgram, and you have got suspended particulate matter 218. Got it? No, no, no. Page, internal page 6. Huh? Maximum is 600. But you see the weather condition. Raining. So during rains, you will not find suspended particles in the air. In rain, if you have found 218, then it will be much, much more when it is dry. Now you come to the next page. Here, admittedly, the sound pollution is more than the requisite.
Admitted in the affidavit also.
Affidavit also.
That means para 4 they have admitted.
Admitted.
It is beyond. That is only, my lord, the non-functioning and functioning both, my lord.
Both. So this report cannot be the basis. 218 suspended particulate, that means the particulate available in the air. You get my point? With rain, you find 218.
But at the same time, bins are also to be created. Have to make sprinklers. So that particular matter comes down.
And that too in a residential area, there is a silicosis. That's this stone dust. If it goes inside, dangerous, very dangerous. Supreme Court has
Equally are very.
from a kid to a senior citizen, everybody is affected.
That report, my lord, distance between house and that stone crusher machine is also mentioned, my lord.
In fact, when we first suspended with, that is 22 first report only, we have around the unit.
That is what I'm saying. Once you have arrived at that conclusion, that's my query to you. Once you have arrived at that conclusion and you have taken a view that this is a health hazard, what you have done subsequently is only on the basis of consent given by the residents. They can't consent. You can't permit that consent beyond the duty imposed upon you, which is the protection of the health of the public at large. Okay. This is done within 3 to 4 meters away from the stone crusher, right? And this is in an ideal situation. There's parameters that have been given in an ideal situation, wherein if we go by the 2013 rules, if it is notified, in a 7-biga plot, if the 2013 rules have been notified, it will come around to 7 bigas. Plot, no, that's what I'm saying. I'm only going by the rule. I'm not here to look into any other things. And not in a residential area within 300 meters, this may be very perfectly fine. But in a thickly populated area, whether this would have an adverse effect. You are not doing, your authorities are just making reports one after other,
We are not
but no.
from this draft rules only assistance. Finally, the consent to operate also.
So this one thing is correct, but Mr. Hazarika and you will admit that the stone crusher has been established within 300 meters from the nearest house. People are there within 300 meters.
Because ultimately, when
That's a part of the game.
that is
so
what is
that,
happening. In fact,
see,
previously
he has a right to do trade, 19. But that is also again subject to limitation, and public health policy is a major issue.
because
it's a major
ultimately,
issue.
if we just also talk about the airport, so we have to run down distance of 5 kilometers, previously barren land on all sides. Adding up.
That is, Mr. Borua, the development that is taking.
Yes, changes circumstances.
But with the changes, the health condition cannot,
condition can
because
be-
19, the right, fundamental right to carry on trade and commerce is again hedged. by the reasonable restrictions.
Big,
So
compromise.
this is something which you can't say because it is operating, because the situations have changed, we will permit it to continue.
No, no, we are not giving any leeway to that.
Okay.
We are being guided.
Now, who will give me this thing, whether the gazette notification has occasioned or not?
From 2-3 sources confirms it, but at the same time, if you're the forest department would be in a
We don't know who had made these routes.
for
Homework to them.
Hmm?
I'll try my level best because that submission was made and also
No,
in
that
their-
submission is there.
in their website, that date of notification, that is there. But there are no other details, my lord. I have just checked it up, my lord, in
What is the date there?
17.
9.
Yes, 21, 21, yes. It is,
21/8/2013.
13.
That cannot be. Who is appearing for the, you are appearing government. Judicial will not be in the loop. It will be the Director of Printing and Stationery. You appear for the Director of Printing and Stationery. You appear. Mr. M. Setia, learned government advocate, is requested to receive instructions from the Director of Printing and Stationery as to whether the Assam Stone Crusher Establishment and Regulation Rules, 2013 has been published in the Assam Gazette. Mr. Mohanto, T.J. Mohanto, learned senior counsel, appearing for the petition, submits that the said rules were so published
Okay.
in the where as per his information, published in the Assam Gazette dated number 393 dated 17/9/2013. The said instruction be received and placed before this court on the next date of listing. Full stop. A registry to list this matter again on how long? 1 week? On 2/9 Julli hobo. On 9/9/2025. And Mr. Burwa, kindly put it in running page in your thing also.
Yes, yes.
Then it will be very easy. Hmm?
That point of time,
It was not
it
there.
was not there.
This is a Xerox. I can keep it in the file.
I can, yes, no problem.
Uh-huh.
I'll give him one of
He'll
that. That can be kept in mind along with the file.
So issues are now very clear. We'll see how you have done it. It took right. Mr. Borua, you can take it back. Keep it with you on the next day. We'll have it.
last inspection report.
I've given it back. And Mr. Hazarika, it's in a populated area. There is already a sort of an undertaking given by you. You have operated it for 15 years, somewhat recovered your dues. You can always shift it out. Huh? Now it's problem. Person died, somebody is operating it, either close it down or we will not permit it to be operated with a health hazard. And these reports clearly shows. Read on silicosis. Silicosis, it's in all probability the word is silicosis. Read on it. Read up.
Regarding that, my lord, noise pollution, not yet answered.
Not yet
But
answered.
it's confirmed that it is beyond.
Noise
Noise pollution, there is a solution in the,
No, sir, we don't want a solution. We want how you,
that doesn't mean that, that will
Not-
close down. It
It-
is on the pollution control department. There is a rules, no statutory.
the pollution control board is only concerned with the objections of the people. Nothing else. Mr. Burwa is only concerned with the objections. No objection, any red industry can be operated.
There has to be acoustic enclosures. enclosure has to be different for a stone crusher. No.
An acoustic enclosure, he puts in all those things, his unit will become unviable.
Mainly, my lord, it has to be, my lord, stone, my lord, is from the original source, it will be within, my lord, 500 meter. That's why it is.
And
inactive
Mr.
forest, my lord.
Burwa, that he has put these systems into operation as per your last paragraph of 8-9, confirm that. I don't want the other reports. Whether the pollution is being created or not is a different aspect. That will come into operation after he operates. Your consent to operate. But to issue that consent to operate, the requisite acoustics,
Fulfill or not.
the sprinklers, everything, green belt, green trees, bifurcation. Show me your satisfaction to that effect. Anywhere, wherever you show me, I'll go through it. On next that we'll finish it, but this is an important issue.
My lord.
And Mr. Borua, make a small note about the dates with the affidavits. Okay.
That I have received my instruction. Marks of the.
Mr. Gogoi, we wanted you to file an affidavit. We are not concerned with your instructions. Why the affidavit has not been filed?
Receive your worship.
But that's your headache, not mine. One week, 10,000. Heard, Miss. We are not concerned. Heard Ms. M. Gop, Learned Counsel for the petitioner. Also heard Mr. B. N. Gogoi, Learned Standing Counsel, GST. Also, on the last occasion, on the last date of listing, last chance was granted to the respondents to file their affidavit, and they said affidavit was required to be filed on or before 18/8/2025. Also, Mr. Gogoi, Learned Standing Counsel, GST, submits that the affidavit has not been filed. However, he has received the instructions and desires and prays for further 2 weeks' time to file his affidavit in the matter. Also, it is seen that repeated opportunities were granted to the respondents to file their affidavit. However, the same was not filed, leading this court to pass the order dated 31/7/2025, fixing 18/8/2025 as the last date for filing such affidavit. The affidavits not having been filed and the instructions having been said to have been received in the matter only recently, this court adjourns the present matter, granting present matter till 15/9/2025. Full stop. The respondents till 17/9, respondents are permitted to file their affidavit in the matter, subject to payment of rupees 10,000. Bracket of 10,000. Also, the said amount be deposited with the registry of this court on or before 3/9/2025. Also, the registry on receipt of the said amount shall transfer the same to the account of the Assam State Legal Services Authority for its utilization by it. Like for example, transfer the same so and so. Also, raised to list this matter again on 15 date 15 17 affidavit on or before 17, right? Raised to list this matter again on 22/9/20. Which one? Mr. B. N. Gogoi be furnished a copy of this order on payment of rupees 10,000 or on payment of rupees 1,000 by the to the registry.
An impact on that.
Mr. Gogoi, you get this uploaded. We are uploading it. You can download and send it. Why should I?
This is my letter.
What?
To that day itself of my lordship,
There is no problem for you. It is your department.
my part I have mentioned.
The effects will be on my,
Why?
when it goes to the department, they'll lordship, no cost, lordship.
Self I have mentioned.
You have tried. I have not.
Still went to the GST office also.
Oh, you had said 15,000, 50,000. 10,000 লিখিছো নহয় 50,000 কৰি দিয়া।
Please, no cost, lordship. Lordship,
50,000 কৰি দিয়া।
we both will be in trouble.
He
lordship.
has written, I'll be, what would be his status before the authorities? What would be his status? You're not thinking about it. What would they think about him? That he is a liar? Why should we make that? No, no, never with a court officer. Never. 50,000, Mr. You are very correct. File the affidavit by 15th. Why this? Why are you acting? Why is your department acting in this manner?
This matter, DCGI, that
And DGGI is very busy, lordship, doing search and seizure and catching fake invoices cases, lordship. We
Very
get the
busy,
bills also,
yeah.
that's why. They're doing very good work, lordship. Why all this? They're doing good exercise, lordship. Search and seizure they are doing. We are getting bail matters, lordship.
and law department.
Yes,
Regarding
lordship.
the Bhoga's the tax of GST.
That is why. Just give me your instructions. Just give me your instructions. No, where is the instructions that you got? Now you showed me. I know in my hand.
Elevated tax, your lordship, it has been
Then why this casualness is not coming up with the affidavit? Why this delay? It's revenue, it's public money. Why are you delaying? Deliberately. Then that is the vibe we get. Please don't make your submissions.
paragraph number 27.
Mr. B.N. Gogoi shall file an affidavit on behalf from the competent authority of the GST department shall file an affidavit before this court on or before 29/8/2025 explaining as to why the affidavit was not filed in terms of the directions passed by this court in the earlier dates of listing. Registry to list this matter on 2/9/2025. In the event the affidavit is not filed, the principal commissioner of GGST and CE GST Bhavan shall remain personally present before this court on 2/9/2025 for explaining as to why the delay had occasion. Further orders as would be required would be passed on the next date of listing. 2/9.
Lordship,
You file an affidavit.
lordship, fifth.
2/9. You are not concerned here. We are not asking for the original affidavit. We are asking for the affidavit why the affidavit was not filed. Second, interim order passed earlier to continue till the next date of listing. You file that affidavit why the delay had occasioned, then we will think about the cost. And thank you for intimating that we should, when it is GST, it should be not less than 50,000.
Supplementary list 57.
Yes. Where is the affidavit filed by you? Have you called it?
Affidavit in reply, yes.
Where?
The
I see.
second item, mal.
Like it is, huh?
But in item 37. Correct, my lord. In item 36, we are the affidavit.
You are appearing for the petitioner in Fozia. You are
37,
Fozia.
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 My lord, the affidavit, my lord, sir, in respect of item Suhana.
Same thing.
That is important only one thing, because when the matter.
You have not taken that plea here. In the other affidavit. What is the plea you want to take now?
There.
Hmm?
No, regarding, as your lordship is aware that during the period when the matter was, the director who earlier stopped the appointment, viewed his own order and given the appointment.
Hmm.
So in their repetition, my lord, I need to challenge that. I need to point out that, my lord, in my counter, that they.
I'm
Well-
permitting you to do that in your arguments. I'll take it as a point of law. Yes. Which one do we take up first? Suhana Begum is Mr.
Yes,
Mazhabin. Yes, we'll hear you first. Hmm. What is your challenge here?
I challenge here in this case, my lord, she been duly selected when her name was forwarded to the director, along with all other selected candidates for approval. All approval were given to all except her case and purportedly on the complaint made by the respondent, and that was held up. So I challenge it before your losses, and where in that case, the respondent number, you was also made private respondent as 5 mile. They did not file any affidavit. Now, my lord, subsequently, when they filed their petition, my lord, I filed my affidavit in the position. Next, second matter, my lord, and director thereafter passed the order reviewing the matter of his earlier order whereby my selection was held up. Now, my lord,
Now, who is holding the post? You are not holding.
yes, my lord.
You're
I
holding.
have been duly appointed and I have already.
That order is under challenge in the second case.
No, they did not challenge it, my lord.
Order is not under challenge.
No, not on it. They did not challenge, they filed an affidavit.
No.
Ah.
I think informed before this.
The
honorable-
director filed the affidavit long back, my lord. I also submitted a reply to, sorry, my affidavit supporting that, yes, I have been duly appointed. They did not challenge it, my lord.
Challenge over here doesn't come. That. Then only, my lord, your lord. We had to decided to counter that repetition where we wanted to bring that, my lord, whether it was permissible under the law. The person who stopped the selection of that particular post reviewed his own order when the matter was.
Okay, where is that order stopping the selection?
It is in Shwana's case, annexure.
Have you brought the subsequent order of the director on record,
Yes,
Mr.?
yes, my lord. I have filed affidavit. And my file affidavit, my lord.
Additional affidavit.
Yes, ma'am. Starts from page 65, my lord. On the first case.
Huh.
Director also filed affidavit in this case, my lord, regarding the order he has reviewed. She has joined and now she is
Trying to training. I received yesterday.
Where is 5/3/2024 in your case, Mr. Abedin?
B.
That impugned order in your case.
Actually, the impugned order is page page 41, annexure 10. Well, this is impugned in respect of both the matters. One is.
What is the date of this 5/3? Okay. Hmm?
It's my lord, as to till the proceeding starts, my lord.
You have filed a reply to the affidavit filed by the other petitioner. You have not filed a reply here.
I filed a reply over here. In my writ petition, they filed the counter, I filed the reply.
Hmm.
Whereas
Where is that? It has come on record.
it has come on record today.
Okay, okay. Okay. Sir Madhumi, have your seat. Yes, Mr. Abedin. Your case is that there was an advertisement, you applied. Selection committee found you suitable. You have placed at serial number 1.
Yes.
Matter was sent to the director. Director cleared all others, but in respect of yours, there was a decision taken
Yes, yes.
that don't do it. For which your name was, the name of the Anganwadi worker for that particular Begaon center was not approved. And that remained vacant, forcing you to come up before this court
Yes.
by way of this writ petition. This court,
And the complaint was on the basis of her, the story was on the basis of her complaint. She
complaint,
was
okay.
also made party. Yes, yes.
there is no interim order here. In your also no interim order. Then you say that the applications made by you were considered by the director, and he, on drawing satisfaction that you fulfill the eligibility conditions and she does not, directed for your appointment, and accordingly you were appointed. Right? That's your case.
And
Yes.
director categorically found that she was not a candidate.
Fine,
to be
fine,
the zone.
fine.
And it is in fact admitted by him in his writ petition. The other day I have also shown.
Okay, we'll see it once more. Don't worry.
Did I admit my?
We'll see it once more, Mr.
Yes.
Let him. Yes, Mr. Abidin.
My lord, as your lordship has seen that there was an advertisement in respect of and one of
Can
the
you take me through the facts once? Page 21 is the advertisement. Date?
my lord, date is 10/1/2023.
And the center is known as
Serial number 32. Kiribasti Panchayat.
Then what happened?
Lord, survey what has said if that area, my house is missed out. So I made a complaint. And in respect of that complaint, my lord,
No, when did you make that complaint?
my lord, I made the complaint on
Page 32.
yes, my lord.
When was the interview? Selection? Mr. Mazabuya, when was the selection held? Mr. Goswami, you are appearing in this matters? No. Director, social welfare, earlier. Date of the selection.
My lord, the scrutiny was made by the annexure to page 33.
Of your writ petition.
Annexure page 34, my lord.
Of your writ petition.
Yes, my lord.
My lord, it seems like your lordship looks at page 40. Your lordship be pleased to see 40 once, my lord. When the survey itself was conducted, then I approached the authority, my lord. And there was an inquiry called, and the inquiry report is 5/1/2023.
When was your application for the first time made, Mr.
But on the basis of my application, that inquiry report is 5/1/2020.
When did you make your application after rejection of your name? That is at page 32.
No, 32 is after the selection process,
Before that, where it is?
page 40.
40.
Goes in. The subject inquiry reports of survey area under Belgaum proposed WC under Dalpukri ICDS project. As per your letter number mentioned above, I have query regarding survey of so and so project on 21/12/2023, along with sector supervisor Srimati Geeta Das so and so, Abura of the said village from Rahman Ali and 5 other persons. As per statement of the Gaubura and local areas, people of Ojia, Tabassum and per statement of the family of Sri the said AWC proposed area, but her name was not enrolled in AWC survey register because of enrolled in voter list of the said village.
So Belgaum is the village.
Yes.
So then a list was published on 18/5/23 wherein your name was rejected. Right?
Name of, no, I was on the basis of this, my lord.
You submitted an application against that advertisement and that application was rejected on 18/5. Right? Then the interview was on 35. On 29/5, you submitted a representation. Now let us see that representation.
Or page 32.
So this is the ground that your area, you are not within the survey area. And you say that do it. So selection done.
I was allowed to participate, my lord.
That's a different thing altogether. 29/5, you submitted a representation. Okay. Then the matter reaches the director. Right?
Yes, my lord.
The order at page 41 is issued.
31, if your lordship looks. Before going to this, though I participated in the selection process, my case was not considered by the selection body at all. And as such, I approached the director, my lord, who then passed this order, my lord.
Where is your approach to the director? Where is your representation to that effect? And what is this 2985 case number? That is nothing to do with this matters. Okay. Let us have the page 42 last paragraph.
Approval for the post of AWW at this Anganwadi worker at Belgaum Anganwadi Center is held up. A complaint was received from Fauzia Tabassum, who was a candidate for the said post regarding anomalies of selection for the post of Anganwadi worker at the said center. As per inquiry report submitted by the DSWO Huzai, it is mentioned that the family of Srimati Tabassum is permanent resident of the Belgaum village and marketed proposed Anganwadi center area, and they are living in this area for last 10 years the CDPO is directed to place the matter in the selection committee and re-advertise for the said post covering all eligible candidates of that area.
Okay.
That was the case.
Hmm.
So at that juncture, my lord, this Swana's writ petition came before this honorable court.
Hmm.
I filed a writ petition. Why
Hmm.
this writ petition also came, my lord, before this honorable court?
Hmm.
My ground was that as the criteria of meritorious candidate should be given the preferred.
Okay.
I-
Now let us have the affidavit of the director. Right? Which is there in the case filed by Mr. Madhabuya. Page 55.
But in the affidavit, they have taken the ground of voter list. That is not the criteria, man.
Let us see.
That is page 50, page 58. First paragraph, last part.
Just a moment. 2 minutes.
Okay.
Mr. Abhinan, if you can come to page 85, your reply. When was your marriage solemnized? Page 85, Aadhaar history, update history.
My lord, other history, yes, your,
85.
it is the second date, when my,
No, forget it. You come to page 85 of Annexure 2.
yes, my lord.
First one, maybe it's your,
No, the last one is the, your lordship, see.
that is the first one.
That is the first one, yes,
First one.
2016.
That you were in Daboka, Ambari Road. That is not connected. Second one, Fauzia Tabassum, care of Hussein Chaudhry, Milik Basti.
Yes, my lord.
This is also outside the survey area.
Yes, my lord.
Huh? Now, why this is required? This is done in 2020.
Husband's original house. Then we shifted to this place, my lord, Begaon. On,
Begaon
yes,
in 2022.
22, and this,
No, be very clear. Till 2020, till 2022, you were in Milik Basti. Thereafter, you shifted, you and your husband both shifted to
Pachim Begaon, Hawaipur.
there was nobody, both of you were in what you call the Milik Basti earlier.
Yes, yes.
So sometime in 2022, you shifted this side,
Yes, my lord.
right? Now you come to page 83. Or you can have page 84, vernacle. Can you read that? Ya Dora Protibedan dia hoise, Sen Sodri Pita so and so. So if Disby, so he's there for 9 years, how could you have been in Milik Basti?
My lord,
Where is that material
I'll
that
tell
you
you.
both were, he was staying there, you were staying here?
no. What I'm saying, both the household, both the homesteads were ours. Both. Only thing is that when we last updated.
Can't help it. That is why your vote still is in Milik Basti. It may not be otherwise relevant. It becomes relevant because of these facts.
No, over here, one thing your lordship would see, advertisement came, I did not know about the advertisement. Before that, my Aadhaar was updated. Why should I be?
That is a presumption. Mr. Mazhabia can also make a statement that he knew this is going to come, so he made it. So disputed questions of it.
But one thing, my lord,
Anything more?
I believe that should not be a disputed question of facts. because
This
the
is
matter
a
of fact of-
satisfaction arrived at by the director. Will not.
No, but
In report, will not.
would your lordship be pleased to, as your lordship has already possibly decided, my lord.
Not
Have you
decided. If you have anything, I have
No,
taken
only
the
thing-
file.
No,
I had decided, then you said something, so I took up the file again. Again, it became tentative.
No, now your lordship would come back to that director's affidavit, my lord.
Director's affidavit.
Yes, ma'am.
Okay, yes. Hmm.
My lord, page 60.
Page
60.
60.
Lecture
Okay.
eight.
Yes. Yes.
So this is from the director to the district social welfare officer to cause an inquiry.
Fine. He did it.
Okay.
Then that's why he put it on a hold.
Okay.
Then you come to page 63.
Yes, my lord. '63 order. My lord, just saying that there was no interim order, and when the record would show, my lord has asked twice the government, the standing council, to produce the selection materials. That was not produced, and instead this order was passed. If your lordship thinks yes, it was done, okay, then I have
No.
no case, my lord.
No.
Till now, they did not produce the examination.
Mr. Abedin, if we hold that you are within that area, this court in the process of considering an issue asks for many things, which it feels relevant at that point of time. But today we have everything before us. There are two issues. One, whether the conclusion drawn that you are outside the survey area is correct or not. Two, that you have participated in the selection process. What was your marks given to you? So that second question would come if the first question is answered in your favor.
Yes.
If the first question goes against you, second question need not be. So the records will mandate the second question only. So the first question has to be answered first.
The answer, that annexure B will save me.
Which be?
Director's inquiry report.
That is a part of that. Thereafter, the matter was taken. You have now filed a affidavit.
Yes.
And therein in page 85, you have brought a document,
Yes.
which creates a further doubt whether you had shifted here or it was just a name shift. One. Two, your voting still continued there.
That
So
will
you
be-
are a resident there, not here. So it's a
No, one-
disputed question
no,
of fact.
one thing, my lord, this
It's
court
a
will-
disputed
no,
question
no,
of fact.
this
We'll
court-
not go into it.
No, one thing this.
And
court-
what is it? It is only a Anganwadi worker.
I understand,
Ah.
but I understand, but whether.
Why
this-
this so forceful thing like it's a post of chief secretary going away?
My lord, for that lady.
How much rupees you get nowadays, Mr.
It has increased to rupees 8,000.
Oh,
My lord,
Earlier it was
what I'm
5,000.
saying,
for 8,000 posts, so
my lord, my only
And
ground
the-
before my lord is.
By that time, he said
No,
that
no, what
she
I'm
is a
saying-
graduate.
she is doing
She-
good
she
work.
is
Let her
graduate.
continue.
What
We are
I'm
concerned with the
She has
children
al-
there.
She has passed
Saying-
here, my lord.
What I'm saying, when the matter was seen of this honorable court for final adjudication, and there was a time when this honorable court very strictly asked the standing council to produce the selection materials.
And that was produced by Ms. Bhattaji had
Whether
produced
this-
certain documents.
No matter whether this review order or.
That is what I want to say. This is not a review order. Unfortunately, this is not a review order. It was put on hold. It was put on hold.
No,
Yes.
it was asked to re-advertise.
No.
Yes.
10-1-23, if you can see.
Yes, yes.
That is the right way of writing English language. Can't help it. If you can come to page 10-1-23.
Yes, my lord, I'm there, my lord.
Where is that 10-1?
My lord,
Page-
That is page 42, your lordship has seen,
Of your petition,
my petition.
42.
The CDPO is directed to place the matter in the selection committee and re-advertise.
This is a one-sided thing. You made a representation, he passed this order. Then
No,
the,
He passed the order on the basis of the district officer's report.
Mr. Abedin, you are aggrieved by that order.
Which order?
That order of 5-3.
No.
Yes, you have challenged that.
I've challenged,
Ah.
no, I've challenged, I said what?
Ah.
I said I took the selection and I was more
Okay, you want a part of that, you want a part of that order to go. We are interfering that part and we are examining whether the materials on record conclusively established.
That part has also gone. What is my submission before this honorable court? When the matter, my lord, this matter is part-heard matter. And during that time only, my lord, this order was passed.
There was no restraint.
I understand.
There was no restraint.
My lord, in almost all the cases, there is no restraint, my lord, and this is normally the authorities, what they say, our hands are up, the matter is before the court. Over here, it's exceptional.
He made a mistake in the first instance. He has rectified that.
No, but it was not a
Okay,
rectification order.
why this rash action then? It's the same director who had passed the 10-1 and the 25 order. Same director or different directors. So
Another-
why did the first director, without even affording an opportunity to her, who was the selected candidate, proceed to cancel this election?
My lord, what I'm saying.
Your
of course, I
query.
Understand. Now, what I'm
Your
saying.
query.
Now, what I'm saying, two aspects. During the proceeding, when it was for final adjudication of both the writ petitions, whether this order could have been passed. That is my first question.
Okay.
That is your lordship to take call on. my
Call. Okay, I'll take
Secondly,
it.
page 64, this is the first case, if I have done, my lord, 2-3 cases of Anganwadi worker or not, this is the first case where I've seen on the basis of voter list, they have decided to pass this order, my lord.
It's not the voter list.
Yes. over there.
Its voter list is used for understanding the situs of your residence, not the voter list. So you are in a different village.
No, could not.
For the purpose of understanding, why not?
No, cannot.
Why
take cannot take up the voter list as a matter, my lord, because
Okay.
today, for last 29 years, for 33 years, I am in Guwahati, but my vote is in Jamnamok. That doesn't mean I don't have any right over here. A simple thing. I
Do
may
you
not
want
transfer my- I may not
Do you
transfer-
want this court online to make a comment on what you have just said?
Yes, my lord.
Huh?
Yes. Today, non-resident Indians also have got the vote.
And we know what Jamuna Mukh is to Mr. Abedin and
It's my heaven.
heaven.
Yes.
And 1 feet is
There
always
is a no
1
cheating
feet
here.
is always there.
Oh.
1 feet is always there.
My lord,
Don't
not-
bring me into
my
more
lord, that other part which I had lots of problem at one stage. I had to satisfy lots of people during those
2-3 years.
No. When that rumor came out, I had to satisfy lots of people.
2-3 years.
But this voter,
So that example will not apply here. Rather, it will be a very good example to
somebody,
support what I was trying to project.
somebody else.
So this order of the director,
It's passed only on the basis of this repetition. That is the-
35, it is dated, what is the latest order dated allowing her to appoint?
16/5/2025.
16/5. When did you come to learn about this?
Only when, if your lordship remembers, when
The
my-
order was passed.
my friend Acharji informed this honorable.
Court. And that was around 2 months back. Why have you not challenged that till now?
My lord, if I remember correctly, and if the biography of these courtrooms are still there, then I wanted to say that we have to challenge, then your lordship. This honorable court suggested that when both the matters are already there,
Okay.
we can take up this matter at
Okay.
that point.
On that coin, we will not non-suit.
On that reason only, I did not.
We will not non-suit you on that reason, on that ground. We'll do it for other grounds.
Yes. It's available. But it seems, my lord, from para 3, because of the writ petition, because of this writ petition only, this order has been passed.
And his selection was stalled only because of a complaint made by you.
No, but it was a genuine.
Without even hearing her.
No, it's a genuine.
Without even hearing.
No, what I'm saying.
Without even hearing.
No, it was a genuine one.
Her selection was done away with without even giving her a notice.
If your lordship takes
We are only on
no,
that.
No, I understand. If your lordship takes it in this way, my lord, I have been left out. I made a representation. Ultimately, an inquiry was there. I was allowed to participate.
But she was
What-
never given an
what I'm saying,
opportunity.
What that CDPO what has done, she did not take my candidature into that picture at all. Then I approached the director. Director asked for a field inquiry. On that basis of the inquiry report was submitted. Then the director realized that there was some illegality was committed, not considering my case. Then it was put to hold, in a sense, saying that you have to re-advertise. Then I came before this honorable court saying that ground is on the basis of merit. I'm more meritorious because she is matriculate, I'm higher secondary. So I stand a foot. So I took a chance that it should not be re-advertised. That is my prayer. The selection should be considered. If I am more meritorious, I should be given the chance. Both the cases are before this honorable court. Yes, with heated argument went from both sides quite a few days. And then your lordship asked on 2 occasions, if the orders are there, that bring the selection materials before this court. Till date, they did not bring. And what they have done, only thing, my lord, my conclusion, the selection materials are not there. They have, what you say, they have
Destroyed it.
destroyed it. And that is the reason this order has been passed in order to finish the case. This order means what? I don't have a case now. This honorable court will simply say, the
Will not
matter
do
ends
that.
because they have passed the order.
We will not do that.
That's happened.
We will only come to a conclusion that
Only, my lord, your lordship,
Mr.
they are
Abhijit-
satisfied this honorable court.
Mr. Abhijit,
Call the selection record. If my name is there and I have been,
Mr. Abedin, we are only considering whether you are a resident within the coverage area or not. If we come to a conclusion that you are a resident of that area, then there are materials here which will demonstrate that you were excluded illegally. Then the selection automatically has to go even if there is an order. On the other hand, if we come to a conclusion that no, you were rightly held to be not belonging to that area, the rest is academics. Heard Mr. M.H. Rajbarbhia, Learned Counsel for the petitioner. Also
only
heard.
thing, can I give a suggestion? Say that if your lordship permits, then court commission can inquire whether my residence is there or not in my expenditure.
No time. That you save it for the appellate forum. Either of you. Also heard Mr. J. Abedi, Learned Counsel appearing for M.H. Rajbarbhia for petitioner in WPC number 2162/2024 and Mr. J. Abedi,
There are 5. respondents.
Learned Counsel appearing for the petitioner in WPC number 2434/2024. Hearing concluded, registry to list this matter again. Biraspati bare keita ase delivery of order. Say. Keita ase. Aru kundina ase olop khali. Sari tarikh, tweet sari. Date ta dia? 16. On 16/9/2025. Mr. J.K. Goswami, Learned Additional Senior Government Advocate, appears for the respondent number 1-2.
Deeply obliged. ma'am.
I'm sorry, there is no slot.
It's okay.
39.
May I please, your lordships?
One, Bill. There was somebody making a prayer in the morning for impleading.
In my petition, I received, I have no objection.
Okay, where is that counsel? Counsel had me, I said, you think yourself to be impleaded? No,
That day.
no, today. There was a council who made a mention. I said, we'll hear the matter, thereafter what happens. He is the president of the Gaon Panchayat,
The Anchalik Panchayat.
Anchalik Panchayat. Okay.
I have objection. In fact, I should have made the
You are basically representing on his behalf only.
Anchalik Panchayat's market, my lord, I represent.
Okay. Madam Goyal, you are for the market,
For for that Bashmura, Bashmura
market
weekly
set up by
by the Jaleshwar Anchalik Panchayat.
Jaleshwar
Anchalik Panchayat.
Anchalik Panchayat. What is the name of the market, your market?
Bashmura New Weekly.
Bashmura?
Sorry, my lord. It's New Weekly Heart of Bashmura.
New Weekly Hut of Bashmura. And this was opened on? When were you given the settlement? It was, you are the first lessee of this market.
Yes.
First lessee.
Lessee, my lord.
What are you?
I am just managing the market on behalf of the Jaleshwar Anchalik Panchayat.
In what capacity?
But they have set up us as to manage the market, and they have their own tax collector appointed who collects the tax directly.
Wait. What is your locus? Who are you?
My lord, here we are, my lord, the president and secretary of that Bashmura New Weekly Hut Market.
How come? What is your locus? How come they could give you?
They have not given us the
Then
market.
how are you running it?
I'm not running it, my lord. I'm just.
Madam, you are the president. You have got no grievance with the other operation of the other private,
Actually, this is our market.
your market.
Yes, Lordship.
How come
For many,
how did you give it to them without any tender?
I'm not
Lordship,
allotted.
Lordship, it's
That's
not
what I'm saying. If you have to give it to somebody, there has to be a settlement under the Panchayat Act. How come you have given it to her? No instructions. No.
We are not collecting the money from the market.
Then what locus do you have? If they have any grievance, they'll come up. Why are you before us? You have got nothing to do here.
We have,
Have you been empowered to file this affidavit, any statement by the Anchalik Panchayat? You are non-entity.
my lord, I'm not representing the Anchalik Panchayat.
Then
But-
who are you?
But
You are just an agent,
yes, my lord may call it.
just
so.
an agent.
My lord may
If
call
the
it so.
principal has something, he will come. You have got nothing to do here. Why should we consider this at your instance?
My lord, because I'm managing the.
You cannot, madam,
I'm
you cannot.
managing-
Where is the letter given to you to manage?
My lord,
Where is the authority given to you?
there is an additional affidavit, my lord.
Okay, where is it?
Page 186.
Hmm.
At page 190, my lord.
This says allotment. How could you make this allotment in violation of the provisions of the Panchayati Raj Act? Where is the tender? Be that as it may, you are there, that is enough. But madam, you have said that you have filed. We consider that you are incorporated. Now tell me, what is this arrangement? Who is she? It says hereby allotted. So this is a Panchayat market under the provisions of the Act. Can you allot it in this manner?
My lord, this, if I may read, my lord, because actually it is not a settlement, and President Secretary New Hatley Market of Katiara are authorized to run the weekly market on the plot of land acquired on lease from so-and-so through lease dated so-and-so. This lease is also not with us.
Madam, they say that you are the president and secretary of newly weekly
Yes, of
hut.
the
Huh?
Bashmura.
Show me how you, what is your group? What is that society? What is that body? of which you are a president.
There is a resolution, my lord.
Where?
That is page 23.
What is this? This is a government market, panchayat market. How do you come in? What is your role there
Page 37, my lord.
of the writ petition? Okay.
My lord, the Jaleshwar Anchalik Panchayat in their that application that they have filed, my lord, they do not challenge our locus to file.
Madam, you don't have any locus. I am asking you. I have to consider your grievance.
That. I'll answer to that, my lord. In fact, even at the time of moving the petition also, this question was raised, and that is how this additional affidavit came. Under that page 37, my lord, 18th April 2023. That resolution is not with me,
Madam,
my lord. In
Madam, your
question-
petitioner might be in trouble. You come to page 37.
Yes, that resolution is not with.
Okay,
me.
fine.
In
No
person.
need, no need, no need, no need of the resolution.
Lord, I am present.
37,
My lord. In
page
person-
37,
Yes,
the resolution is to permit one Shah Alam to collect authorized tax,
yes,
right? Whereas in terms of page 190,
yes, yes.
you are allowed. How can a resolution have two?
My lord, my lord, I'll just try to clarify, my lord. In this, my lord, what has been allowed is in the resolution by the General Standing Committee in its meeting dated such and such, Sri Saha Alam, tax collector, Jaleshwar Anchalik Panchayat is hereby authorized to collect revenue on behalf of Jaleshwar Anchalik Panchayat from the following markets until further order. That is the Bashmura weekly market. So this market is run by the Jaleshwar Anchalik Panchayat.
This is the same market we are concerned with?
Yes, same market.
Okay,
And,
now.
and my lord, this since it is not been settled with us, so we are not authorized to collect money from the market, my lord. And that is why they have appointed Shah Alam the tax collector. Now, so far as page 190 is concerned, my lord, this says in pursuance of the said resolution number 2 as General Standing Committee and in pursuance of order dated 18th April 23, Bashmura weekly market Katihara is allotted. This allotted word is there.
What
and,
is this 18,423?
And
That is page 37.
page 37.
Yes.
Page 37. And what has been allowed, my lord? The President Secretary, that is the writ petitioners, my lord, the new weekly hard Bashmura Katihara authorized to run the weekly market on the plot of land acquired.
That is what I'm telling you.
Yes.
What is the legal status of a market body? Which body was only created that day? When did you form your body? Who are you? Who are you, madam?
My lord, we are a market, my lord, just like the writ petitions. in
How
the
can
other
that be?
case, my
You
lord.
be a market. The market is
Is a
Anchalik Panchayat.
market is not the Anchalik Panchayat.
Yes.
Anchalik Panchayat is a institution, it's an authority, my lord.
Madam, it is its market.
Yes, yes.
It is its market.
Yes.
So who are you?
My lord, I'm only managing the market.
From where did you come to manage this market?
My lord, the Jaleshwar Anchalik.
What is this body?
Uh,
President Secretary, New Weekly Hatma. Who is this? What is this body? Who are its constituents?
My lord, that resolution.
Forget the resolution. We want your answer. Who are you? What is your locus? What is this body?
My lord, the Jaleshwar Anchalik Panchayat has just asked us to manage.
That is what I am
market
telling.
And
Madam,
since
madam,
the
why did
resolution-
it not ask madam to manage? Why did it ask
Since
you?
the resolution is not there, my lord, they are already having a market, my lord. They are a group of individuals managing a market.
That is a different thing altogether. There is an existence. They have an existence.
They do not have, my lord. That is exactly, my lord. That I will.
Now
say, my
tell
lord.
me first your
My
thing.
lord will say who are they, my lord? Who are the writ petitioners, my lord, in 237? My lords may go.
Madam, you come to para 2 of your petition.
that the petitioners are running a cattle market granted by Jaleshwar Anchalik Panchayat, Katihara, on land granted by the Panchayat. I do not say settlement because it is not settlement. We are not getting any,
That is,
we are
madam,
not allowed to collect any money from the
madam,
market, my
you
lord.
are allowed to manage.
My lord.
Who are you?
My lord, someone authorized by the Jaleshwar
Oh,
Anchalik
who
Panchayat.
are you? Forget the authorization. Who are you?
I am,
What is your role? What is your background?
my lord, let me take that I am private, two private individuals,
Two private individuals.
the president and secretary,
Okay.
as
We
I,
are interfering with that. This will not permit.
my lord may,
If the panchayat has any grievance, they'll come up.
my lord, is not, my lord, here,
What is your right? If they have asked you to manage, you manage. Have they authorized you to file this case?
my lord,
Where is the authorization?
that,
You have not disclosed.
if that resolution number 2 is there before this court, my lord, that resolution 2 is not be with us, my lord. If the Jaleshwar Anchalik Panchayat is there, is represented here in the other writ petition, my lord.
Whoever it is, we are not concerned. We want it from you. Then we will move forward.
My lords, we are in a
Madam,
226
madam,
petition.
I asked you
My lords.
that this is my premises. Madam, you are very expert. You manage it. Right? Then there is some people coming in, making disturbances and all. You are only to manage. If there is something that is for me to look after, or I should authorize you.
In the resolution, authorization was done, my lord. I do not have that resolution, my lord.
That is up to you. We are taking up this matter for final hearing. Now we are not adjourning. Today morning I did not adjourn. And last date,
We are
madam,
not seeking an adjournment.
last date, it was a clear understanding that we will hear this matter finally today.
Yes, yes.
So we are hearing it.
I'm not
So
seeking.
first is locus.
I'm ready for the ready for
Locus.
hearing, my lord.
Locus.
My lord,
Yes, you is appearing. Yes.
side is appearing in
Come.
the matter, my lord.
How come? Is this a way to do? Is it permissible, Mr. Doctor? Not at all. How? Then why this was done?
Lord, it was page 190 is totally illegal.
90.
190. Because
This is the property of the panchayat market. And what is the procedure?
105 is saying, my lord, without settlement, we cannot.
Anyone.
My lord, there is a difference, my lord. Jaleshwar Anchalik Panchayat, your counsel appearing for the Jaleshwar Anchalik Panchayat. My lord, Jaleshwar Anchalik Panchayat is telling before this court without filing an affidavit. I don't think, because I have not received a copy, I do not know whether it is filed, that its own order is not correct. This I do not know, my lord, what the Jaleshwar Anchalik Panchayat is doing.
Okay.
My lord.
Okay, madam. This order is perfect. Now show me your locus.
My lord, that is what.
To institute these proceedings.
Let my learned friend represent that resolution number 2.
Forget the resolution. You show me. When did you file this case?
This I filed in, I think, June.
16 June 25. This is 24-23. There was.
Jaleshwar Anchalik Panchayat is
madam,
already present, my lord.
Madam. Little bit time it takes for this court to understand. So bear with me. From 23, there was no threat of any problem. Threat came sometime in 24-25. Where is the resolution authorizing you to file this case? What right do you have to file this case? This order is of 23.
Yes.
And you filed this case on 16/6/2025.
My lord may just kindly bear with me for a while.
I'll bear with you till you ask me not to. Yes. Yes.
I will always ask my lord to bear with me all the time, my lord.
You make your submissions.
My lord,
You got my point?
I have got
Make your
my lord's point. My lord, I'm just keeping the locus aside for a while, my lord. So in this writ petition, my lord, what is challenged is the order dated 30 May 2025 and, sorry, 30 May 2025,
Page?
page 185. Page 185, my lord. In pursuance of the communication received from the Honorable MLA, so-and-so Jaleswar, so-and-so LSC, by so-and-so dated 13 May 2025, and report of the Circle Officer Lakhipur Circle dated 28 May 2025, permission is hereby accorded to reopen the Gornagar Damri Bhasha Tinali Pasuhat on Friday with consideration of following conditions. Here it is allowing that Gornagar Damri Bhasha Tinali Pasuhat on Friday with consideration of the following conditions. Now, who is Gornagar Damri Bhasha Tinali Pasuhat also may be, no, they are not the market matter. That question, if it arises for me, it arises for them also. What I am trying to point out, if finally this Honorable Court found that there is no locus, may throw out. But what I am also trying to point out, that when we approach the Honorable Court under Article 226 invoking extraordinary jurisdiction, and we as officers of the court, we do represent our client, no doubt, but then as officers of the court, we have a duty to put pictures correctly before this Honorable Court, not to distort it, and thereafter, my lord, if we can persuade this Honorable Court on merit, we have what we want. That is what I am trying to point out. Now this, yes, Gornagar Damri Bhasha Tinali Pasuhat is not the council representing here. They purport to though. Now, on Friday, with consideration of the following conditions. Now the conditions, my lord. The animal market, and I hope by the Jaleshwar Anjalik Panchayat Council who is representing from the government side will be fair to this Honorable Court and to the parties both sides. The animal market should be duly established as per provision of established law. The Animal Market Committee shall issue proof of sale and purchase of animal in Form G under Rule 10 so-and-so of the Assam Cattle Preservation Act 2021 to the purchaser and maintain proper record for inspection of the competent authority. Next, a permit for transportation or of cattle from the market issued by veterinary department. Excuse me, sorry, I expect you to be fair and please do not disturb kindly. Sorry, huh?
Mr. Doctor, please.
A permit for transportation or cattle from the market issued by veterinary department in Form C under Rule 81613 of the Rules of Assam Cattle Preservation Act 2021 must be produced by the purchaser, and for the sale of auction of cattle must be for animal husbandry and agricultural purpose as per section so-and-so of the Assam Cattle Preservation Act. Violation of any of the above conditions will invite immediate cancellation of the certificate of registration and attract punishment under relevant law. This was the order passed in favor of the Gornagar Damri Bhasha Tinali on 30th of May 2025, which purportedly is represented by the private respondents. That is at 185. Now, this order is challenged. Now, before this order was passed, my lord, I will just take my lords to just two more annexures and the decisions of and one direction passed by this Honorable Court. That is at page 70.
70. Yes.
That is the order which I read just now was 30th May 25. And this was preceded by two speaking orders pursuant to directions of this Honorable Court, which I'll bring later, my lord. This is a speaking order passed by the Deputy Commissioner, Gwalpara, my lord. In this speaking order, a direction passed by the Honorable Court in also read in that second part, my lord. Honorable Guwahati High Court's order dated such and such passed in IS so-and-so, WPC 764, Raw Mari Market so-and-so. Pursuant to this, my lord, I'll just try to cut short, although like this, it's important for me though.
Okay, on
May I read
the, madam, were you before this court earlier? Or this is the first case you are filing?
This is the first case I'm filing.
So you were allowed on Friday and they were allowed on Monday and Wednesday.
Yes, other than Friday, yes, Monday, Wednesday, Tuesday also maybe. As per their choice. Now now so far as my lord, in the circle officer's report, my lord, that cause of action has been given. First, second part, the third one, my lord, with quotes, my lord. The circle officer, my lord, had got it page 70. The circle officer Lakhipur visited the site of Gornagar Bridge Tinali Pashuhat and seen that Bashmura Pashuhat and the Gornagar Bridge Tinali Pashuhat are running in the same day, that is on every Friday, in a distance of approximately 1 kilometer under Katahariara Gaon Panchayat. But the Gornagar Bridge Tinali Pashuhat is functioning on a private land. Now, all the records were considered, my lord, and it is also seen in the third last sub-para, my lord. I'm skipping, my lord, although everything is important for me. It is also seen from the record that Jaleshwar Anjalik Panchayat collected a huge amount of government revenue from the Bashmura Pashuhat. This is important, my lord. During last and present year, the Chief Executive Officer Zila Parishad Gwalpara issued a letter to the Executive Officer Jaleshwar Anchalik Panchayat Katahariara, wide letter dated 4th April 23, where it is stated that Jaleshwar Anchalik Panchayat may open new market including livestock at Bashmura, observing necessary formalities as laid down under the Assam Panchayat Act 1994 and relevant rules. Then the inspector so-and-so Lakhipur police station also gave a report that they are running, that Gornagar market, my lord, the other market is running with their business since 2013, my lord, without paying taxes. And etc. to the government, and also newly permitted weekly new Bashmura Pashuhat were operated on the same day, that is Friday. Concerning this issue, it may lead to conflicts between both the parties. Further, the Honorable Guwahati High Court, in its order dated 2nd September 2022, passed in IA 2614/2022, linked with WPC number so-and-so 764 of 2020, filed by one Rawmari Market, observed that although a person would be entitled to carry on business of conducting cattle market on his private land, but such market would still remain subject to the requirement of any kind of permission or license to be obtained for running such market from the authorities of the state. In conformity with the observation made by the Honorable Guwahati High Court and on the strength of report submitted by the Circle Officer Lakhipur Revenue Circle, the District Commissioner Gwalpara hereby passed the following order. The weekly market Bashmura Pashuhat will henceforth run the market every Friday as per the existing schedule, considering the fact of government benefit, and the other market, my lord, the Gornagar Bridge Tinali Pashuhat will run the market either on every Monday or Wednesday or as per their choice except Friday, with a direction to deposit the government revenue in time. Now this copy, my lord, has also been given to the writ petitioner, to the my lord, the President Secretary Bashmura Pashuhat and Gornagar Bridge Tiniali Pashuhat for information and necessary action. And therefore that some resolution is there, my lord, some inference can be drawn from here. Now after this, my lord, what happened? The other side, my lord, they came in a writ petition 4139.
And the order of the government had upheld the order of the director, the district commissioner.
In 439, I will just place one thing, my lord, as to how the case was projected, my lord. Paragraph 7, my lord, if I may read of that judgment at page 75. Because we were not present, my lord. The other side was present, writ petitioners.
I got it. I've read it now.
My lord,
I've read it.
what I'm trying to say that in this writ
That
petition,
is an absolutely irregular market or irregular persons. We got it. That's your projection.
my lord, not exactly, my lord. On that ground, my lord, may non-suit me also, non-suit them also. But what I am on is that in this 4139 writ petition, what was projected before this honorable court was, I'm not even saying who they are now for the present. Section 107, my lord, of the Panchayat Act. They had annexed a revenue receipt projecting that to be a license issued by the panchayat authorities
Hmm.
and projected before the honorable court that under section 1, we already have a license from the panchayat, my lord. That is, that copy is, I will show, my lord, there's not a license. That we already have a license from the panchayat authorities. So the honorable court held that only now what is to be done, that they need an approval from the government department, and that is why the honorable single judge relegated the writ petitioners, my lord, to go to the panchayat market. Now I will just page 159, my lord, which they projected as a license, and this honorable court also made such an observation. Did not give a finding, but it's an observation that they projected. That page 159 is a my lord has got it.
159.
159, yes. Got it?
Just a moment. Who is Bodrul Islam Talukdar, the private respondents? 159.
159.
Hmm.
I will at least not distort facts, my lord. I'm ready to be non-suited also.
That we know.
The page 159, I'm grateful, my lord. That license, my lord.
Hmm.
Then it is written under section 71 and 72 of the Assam Panchayati Raj Act 1986. Whereas we are already having 1994 Act. Then it's book number so and so for the year ending such and such period 1st July 2024 to 36/2025. Now what is this? The so and so, they do not even say whether it's Assam, sorry, Gaon Panchayat or Anchalik Panchayat, but I take it from the seal and signature that it is not the Anchalik Panchayat. Hereby grants up to President, Member Secretary, Gaur Nagar. Now this question, now again, who is this President and Member Secretary, Gaur Nagar, because he is not a authorized or a legal entity residing at Bistinali, so and so, the license to be valid within the jurisdiction of Katihara Gaon Panchayat for the undermentioned purposes. Poshuat rate, the rate is of the rate so and so, 2083, amount is so and so. And who is signing it, my lord? Is the tax collector Katihara Gaon Panchayat. Now whether under the act, since the Anchalik Panchayat is represented on the other side also, whether the tax collector has the power to grant the license to run a cattle market, my lord, that is one question, my lord, which I leave it for the time being. Now, with this in the projected by the writ petitioners, my lord, the 75 at page 75, the directions was given that you go to the panchayat department and seek an approval. But this in this writ petition, the honorable single judge did not interfere with the deputy commissioner's speaking order, which I have read. So that remained. Now, after they went to the panchayat, my lord, at page 76, page 76, 39, 2024.
Therein also no approval has been given. Rather, the order of the deputy commissioner has been upheld.
Upheld. Now, thereafter, they came with the writ petition, which I have got it tagged along with my writ petition 237. That is at page 79. Now, in this page 79, they challenge both the deputy commissioner orders as well as the order passed by the panchayat department. This honorable court had issued notice and no interim was granted. Now, suppressing this fact that this writ petition is pending, they approached the district development officer, Gwalpara, and district development officer, and I don't want to really input words, but I have made them alleging malafide. I have made a deputy commissioner and the district development authority a party, and they come up with the order that I impugn in my writ petition. And this honorable court also on the question of locus, my lord, wanted to throw me out. But when considering these facts, my lord, I said that I'm in a 226 pointing out certain projections, distortions that are being projected, and we are not here to get some order for our clients. This honorable court may dismiss my writ petition also if this honorable court thinks. And my lord, I have nothing. Okay, I know that I need to, question of locus, even I asked for this resolution, I could not get it today. There's, I think they will get the resolution today. Maybe the BDO has been of the Anchalik Panchayat, who is a executive officer of the by law is the ex officio officer of the panchayat, was busy and has called them today to give a copy of the resolution.
Madam,
And
done with, we have got your point. We have got your point. Anything more?
yes, my lord. One thing more, and now, my lord, the implement that has been filed in 237, my lord, bringing certain facts, my lord, certain facts that day, my lord. In fact, I'm obliged to this honorable court just as a passing observation, as a friendly observation. This honorable court said something, so I said the court said something. So I think we need to really understand what this honorable court said, although it was not an argument. And then I went through the petition, my lord. The implement petition is has not come with clean hands. And in that implement petition, my lord, it is revealed from the implement petition that what the writ petitioners have claimed, that they are running the market on the land held by the writ petitioners. The implement applicants have revealed that that was not correct. The implement applicants also have land wherein that market is actually running, and they have not been represented, and the writ petitioners did not take their consent and authorization to come up with the writ petition. I'm not on the implementing petition, my lord, but I'm still on the writ petitioners, my dear friend.
Mr. Abedin. Yeah, yeah. No. You, there is a time to reply. Yes.
And my lord, yes, and one more thing, my lord, the background, I'll just put one thing, my lord. Now, so far as the writ petitioners as well as the applicant who has come for implement, my lord, all throughout in the writ petitions, my lord, not only this petition, that 4139 also, and earlier writ petition also, what they had projected, there was one case of Rupam Talukdar, which was disposed of in 2019. Sorry, 2009. Now, in the Rupam Talukdar, it was a writ petition
Private.
by the division bench, my lord. It was
Private market.
yes, that market on private land, and what they had challenged there was the panchayat's power, authority to tender the market on the of a market
This court
which is
said
running
you
on
can't do
private
that.
land. So the honorable division bench said, setting aside section 107, because 107 power was there, setting aside 107, the honorable court's division bench said that if it is a private land, you have no authority, that my lord knows. Now, they have taken Rupam Talukdar all throughout. Rupam Talukdar was in the field, my lord, is in the field also to the extent. But in 2021, when the Assam Cattle Preservation Act came into force, then the scenario changed, because the honorable court had dealt with section 105. Section 105 of the
105 and
105, 107 of the Panchayat Act. So Rupam Talukdar held the field. But when the Assam Preservation Cattle Market Act, that IA that I have enclosed, my lord, that IA that I have enclosed, I brought it before the honorable court by representing another party, my lord, that on the strength of the Rupam Talukdar, they got an interim order, although on the twisted facts it was all right. All expired the revenue receipts they had given. Anyway, I'm not on that now. So the honorable court said, now that Assam Cattle Preservation Act has come, I have read that part where it has been quoted by the Deputy Commissioner, that you have to follow for cattle market, not for other markets that they are running. For cattle market, you have to follow the provisions of the Assam Cattle Preservation Act.
Is there a provision for settlement of a market under the Assam Cattle Preservation Act?
No, my lord. No, there isn't. Now, cattle market can be run by any person, subject to that they have a registered market, they have a license. Private individuals, my lord, they have market, they have license. These are the two basic requirements from the other things also which has to be followed once they get that, my lord. Now, so far as the group of persons, the writ petitioners that is on the other side, my lord, they neither have license, they neither are registered. Now, whether I have locus or not locus, my lord, I leave it. But so far as the Jaleshwar Anchalik Panchayat is concerned, the Jaleshwar Anchalik Panchayat under the Panchayat Act is empowered to regulate all markets. Unless there is authorization, approval, my lord, unless there is approval from the Anchalik Panchayat, my lord, there can be no market. Now with the new
Assam
provision,
Cattle Preservation Act 2021. Yes, madam.
my lord, that note in that new provision that has come under the Assam Panchayat Act 107, my lord. This has come into force in 2023, my lord, of 19 October 2023. Assam Panchayat Act, my lord, has had it. My lord is with the cattle preservation.
No, please proceed as per your opinion.
No, it's okay, my lord.
I just wanted to
Both-
clarify something. I'm just looking at it. Madam, done with
My lord, that only those two provisions, my lord.
105, 107.
Ah.
Deemed read.
That 107, my lord, which has been just brought in October 2023. Now here it says, no private huts and fisheries shall be allowed to operate within the area under the jurisdiction of a Gaon Panchayat without prior approval of the concerned Panchayat authorities and government. The Panchayat shall impose such fees as may be prescribed. My lord, I may also point out, my lord, because they have taken a ground in the writ petition also, this section 107 was brought about, my lord, because of a challenge made to the provisions of the Assam Cattle Preservation Act by the Anchalik Panchayat in a writ petition. And when that writ petition was pending, and it was more or less expressed by the court that this could not have happened, then during the pendency, this 107 was brought in. So perhaps that writ petition, I do not know whether it has become infractious, but it is pending.
Okay, ma'am.
Now,
Done with.
my lord, just one more. Sorry, my lord. Just one more, two more provisions I will show in the Assam and the Panchayat Act itself. Now, section 19
Of?
Of the Assam Panchayat Act. 19, then Roman 17, 1. My lord has got it. So these Gaon Panchayats have been given the power for regulation of fairs, including cattle fairs and festival fairs. And so far as Anchalik Panchayat is concerned, my lord, that is section 49, 49, then 18A.
Got it.
Regulation of markets.
Admitted.
Yes, my lord.
Have you finished?
My lord, so far as the legal position is concerned,
That's all you have finished.
except my
Now, can I now?
yes, yes,
You're
that
I've
means
voted.
the-
Now can I ask you?
remains
Now
the-
can I ask you?
my lord, by all means, my lord. I bow down, my lord.
Madam, you are just operating the market.
Yes.
Are you being paid a fee for that?
My lord, some like for kind of just like agents, like we are just paid some remuneration.
Where do I find that?
That is not.
Where is your statement to that effect?
That is,
Where is your statement to that effect that we are being paid money in this manner? One.
That is not there in the writ petition.
You don't make any payment.
I don't make any payment.
Payment to the panchayat to run the market,
My lord, the money is to run the market. No.
to operate the market. You are not paying anything. You are not paying anything to the panchayat.
So far as that market, so far as that page 58, my lord.
58 of the writ petition. Yes.
Our writ petition.
Yes.
That is my lord, at page 62 is a better copy, my lord.
62. Okay.
The Jaleshwar Anchalik Panchayat
Hmm.
received with thanks from such and such in Azula.
This is the money which is receiving from the sale that is taking place in the market,
Yes.
right?
Besides that, that tax collector is collecting the tax for the for the cattle's the tax.
Tax means the toll, basically. It's a toll.
Yes.
So this is a toll,
Yes.
right?
This is not a toll.
And this is, what is this?
A toll collection. It is said. Sorry, my lord. Toll collection.
So you have got no role here also.
Yes.
What is your statement in para 31?
Yes, I have said that.
Madam, how can you are just managing. If you are managing after payment, then 105 comes in.
After
This says that you are making a payment to be permitted to operate. That means you are the one who is collecting the tax. How can you?
My
Who
lord,
are you?
My lord, there is a tax collector. I don't collect that.
This is your statement, madam, in the writ petition, para 31.
In the writ petition,
Para 31 is been
that I
shown to be true to your knowledge.
able to operate. I have nowhere said that I have been settled with the market.
Madam, what is this? You are paying money. Whereas you say that you are not paying money in the first half and your submissions, but you are paying money, advance tax to the concern. Why are you paying advance tax?
My lord, what I am not paying money means I am not paying any settlement money because
Madam, this is a toll, advance toll.
at para
So where is the power?
para 31 of my
Where is your power?
para 31 of my writ petition.
Yes.
My lord, para 31.
There is a loss being caused to you. How? Who are you? How can a loss be caused to you? You are nothing. You are just an event manager.
My lord, I may be an event manager, but I have been given to hold and act as a president.
That is what I am
and secretary,
asking you,
my lord,
madam.
Not in my
I am
individual-
asking you, madam.
Lord. That locus I said, unless I
Madam,
produce that
madam,
resolution,
madam.
my lord.
Who are you?
That,
Why did the body, the panchayat find you, not anybody else?
my lord, that the panchayat,
This is a body. How can there be a
that the
managing body?
that
President, secretary, who are you?
that the panchayat can answer, my lord, because I do not have the resolution, my lord. I requested for a resolution, my lord.
Sorry.
Then since the video is not there, I could not see the. Yes, this time I'm saying they have appointed a tax collector. The tax collector.
You have, madam, you have paid. Accordingly, the petitioners have paid leviable tax
Yes.
for every quarter, and the last paid is from 1/4/25 to 36. Why are you paying a tax? You are nobody. You are just an agent.
I am just an agent, but my lord, the collection is happening there, my lord.
There is much here. This is not.
It is not what is being actually.
That is what I'm saying. What is being projected is not what is there.
Yes. Yes, that is correct.
You have
That is
got no
correct.
locus, madam.
What is, my lord, so far.
So we are not satisfied with your locus to make this challenge. We'll give liberty if the panchayat at any moment wants to come in,
The
they'll come in.
Panchayat is there, my,
They'll come in,
but
they,
let them say this, my lord. If the
will
resolution.
not say,
if the
madam, I am entertaining. Why should I entertain
My
a
lord.
body? This is not a PIL.
My lord, if the resolution.
This is not a
My
PIL,
lord,
madam.
when there is something shown before the honorable court that there has been, if I may say, misuse, abuse of the powers of this honorable court, it is to some
Madam,
extent it's a PIL also.
madam, if it's a PIL,
It's a PIL also.
it's a PIL, then go file it in a proper format before the, if you want, I can request the registry to place it before the Chief Justice.
That, my lord, I surrendered so far as the locus is concerned that unless I place the resolution, this honorable court may not suit me. But what I am saying, so far as the writ petitioner is concerned,
Mr. Dotto, tomorrow, 2 o'clock, get me the resolution. Heard the parties at length. I heard Ms. B.S. Goyal at length. Hearing remains inconclusive. Registry to list this matter again tomorrow, 2 p.m. by slip query. Mr. S. Dotto, Learned Standing Counsel, Panchayat and Rural Development Department shall place before this court the certified copies of the resolution adopted by the Joleshwar Ancholik Panchayat in its meeting held on 13/4/2023. Also, a scan copy of the certified copy. First thing, always priorities keep changing.
So today, last thing.
Today, the first thing we are now is for us whether madam has
Not
locus.
saying the last thing by pleading petition.
We'll consider your petition. Tomorrow. It will come part only. Madam,
back to my lord.
have your instructions how you are permitting, whether they are paying, if they are paying, what they are paying. And if they are paying, what they are paying, how can you violate 105?
Grateful.
Madam, tomorrow. Yes, Mr. Chaudhary. Oh, Mr. Goswami.
Yes, Lordship. Item 29.
Your review.
Yes.
Yes,
This matter.
Mr. Sinha had last day said that you have to make further submissions.
No
That is
further.
why I
Actually,
kept it.
there
He was
was
very
a
emphatic in that.
there is a miscommunication, Lordships. Actually, I could not explain to him properly. All I said that you can just tell the Honorable Court that we have, in terms of Lordship direction, we've submitted the written submissions and Lordship will pass that. In fact, there was something I could not communicate it
Okay,
properly.
fine.
So therefore,
Heard Mr. M.
our
Goswami.
written submissions are on record, Lordship.
It's all there.
Yes.
I wanted to fix a date for delivery of order. Then I didn't want to disappoint him.
Yes, Lordship.
Mr. Goswami, M. Goswami, Learned Senior Counsel, has made further arguments in the matter. Also, hearing concluded, a registry to list this matter again for delivery of order. All of month, 19 month, 18/9/2025. So we'll pass the orders.
Yes, Lordship may excuse my presence.
You need not, it's only for delivery of orders. If you want to come, you're always welcome, but we don't.
No, certainly, Lordship. Grateful, Lordships, grateful.
I also heard Mr. N.J. Khatonia. Really. Anything? Nothing?
May I please, your lordship, my lord, in this matter, response number 4 expired, my lord. The file and
Item given?
30, 30. Oh, so
20. Yes.
Well, I have served a copy, my lord, by Rasta. Affidavit.
Writ petitioner. This table might have seen it. Oh, ho. Yes, yes. Yes, what is your ground?
My ground is my lord expressive skill.
Hmm.
Title for the
Okay. And what have I held on that?
against the experience.
Where is my conclusion to that effect?
Lordship has my lord that these facts.
Okay, fine. If that is not a error, if that is not been taken, you go up on appeal. How can it be here?
Factual.
It was there.
Placed before lordship.
It was there.
Not placed before lordship.
Oh, it was existing fact.
Yes,
It is not something you discovered thereafter.
I have discovered thereafter.
No.
I have discovered thereafter, my lord.
That he got lower marks.
He was working under the SSA, working in the school. The results of the students of the cannot take the credit. He was working in the SSA.
That will be a view, and my view,
That is one aspect.
and that is a fact which you knew when the matter was being heard.
Under RTI, my lord, I obtained that facts.
Okay, show me your
As he
RTA.
is working
Show me your RTA.
RTI application, also you'll find it 37. The reply is at my lord, is 43.
Okay. What made you to prefer this RTA? What is the basis of this information that led to file this RTA?
In school,
And what is the finding in this order with regard to leadership? No, something which have been said.
with 4 marks. My experience, my lord, per day, that is, I admit that. Yes. It's the ACR, my lord.
So what is the ground for review? Only that leadership marks.
Leadership marks and the my lord, against the experience said.
Experience?
Experience, my lord. He was initially, my lord, appointed as my lord intermediate teacher.
Okay, that was, I think, argued.
Intermediate teacher. He was upgraded on my lord 5/7/1996. And he was working in the school up to my lord 2015 as graduate teacher. Thereafter, my lord, he was working in the under SSA. So his experience will be counted from 1996 to 2015. Counted, then it will be 18 years and 8 months. The required experience is 17 years. 17 years is deducted, then 1 year and 8 months is. Then he has not completed even 2 years of additional experience. He was awarded 3 marks against 6 years of experience, my lord. That cannot be given, my lord. Says, but the office memorandum says against it's completed 2 years, he will win 1 mark.
You are who? You are the petitioner in that.
I was the my lord, selected candidate, my lord. I was appointed as.
You are Jointa Kumar Borman.
Yes, ma'am. My
Has this order been implemented?
no, my lord. Till that he had.
Yes, why? Why it is not being implemented?
My appointment has been withdrawn. My appointment has been withdrawn, but
Has sent.
yes, my lord, it is yet to be finalized.
Yes, Mr. Khatuniya. No, no, fine. What about this review? Give me your grounds. Where is your grounds here? Page 9. So he was with SSA from when to when?
From from 20 to 2015,
22.
2015,
Hmm.
7 to 2018.
Advertisement was of?
Advertisement was of 2018, my lord, December 2018. Years is counted, results of the students, 18 and 17. 17,
He was not there.
he was
Fine. Then next.
other
So how many marks will be reduced?
4 marks.
4 marks. Okay. Then
Then the against
how much was given to him? 4 marks was
4
given.
marks was given.
Okay. Then next.
Experience said, then 6 marks. Counting that 3 years in the SSA also, my lord, along with the experience as intermediate teacher. Well, his upgradation was on 5/7/1996.
5/7,
1996.
1996. He became a graduate teacher.
Graduate teacher. If 17 years malad, a mandatory experience is required, if 17 is counted with 1996, it will be 2013. 5/7/2013. Complete 17 years of teaching.
So advertisement is of 2018.
18.
He has it.
He is not working in the school. Working as a graduate teacher. He is working as a malad BRO at the SSA. That period cannot claim as malad graduate teacher.
3
For that
years.
period. 3.
So if it is 1996, 2018, how many years he has from 2018 onwards?
My lord, up to 2013, 17 years.
So he has
7,
22 years. 22 years experience. Even if we remove this 3 years, it still will be above.
I'm giving the calculation.
So that is not a ground for review.
1996 to
Some which I have to go examine, find out, that cannot be a ground. Next one.
the ACR lost. ACR was initiated by the principal.
Have you challenged that? ACR, there is already an existing ACR, right? Wherein the authorities have deemed it that the ACR will be written by them only. They have written it. Nobody has challenged that.
Against ACR, no marks was given.
Now,
Marks was
because
given.
why? It's not for this that he is not serving. It is because that there were double entry or something, I forgot.
Yes, yes.
So these are not the grounds for which it was denied. So
The principal has initiated the ACR.
be that as it may,
Under whom he was not working.
fine. That is for you to make a separate challenge, not this. Review is not the answer.
Marks is deducted even if
And fake results of HSLC examination. So file a FIR against him. He has submitted false documents. Fine.
But he is the mark against the
I'm sorry.
of the ICS.
I think we had dealt with all that was placed.
Office memorandum says, that, my lord, against leadership skill at 40, when also will find the office memorandum. Then for the results of the student of the school in which the Mr. is working.
Yes, what is this, Mr. Khatonia? When somebody is outside the school, this SSA, it's a deputation. So he will not be entitled to the marks here. School marks. Right or wrong? How do you mark that person for experience, administrative ability?
Get the
Okay.
working in SS. Also, he's doing some work. Or SSL. Work is done.
Oh.
Especially for the results of the students. That's his skill.
You have entered appearance. Heard Mr. Ayat Sekia, Learner Council for the petitioner. Also heard Mr. NJ Khatonia, Learner Standing Council, School Education Department, appearing for the respondent number 1, 2, 3, 4, 5 also. 5. And Mr. D. Gugui, Learner Council, appearing for the respondent number 6. Also, raised it to list those matters in on so and so date of the year. 23/9. Nidiva, last one Nidiva. Dear. 17 dear. 17, 18 dear. 18/9/2024. So, we'll finish off the matter on the next. And Mr. Khatonia, just examine this issue.
Regarding allotment of.
And Hakigul.
He took part in the selection process under SSA. He was
Okay, fine. We'll see.
he was sent on by the department.
Yes, Mr. Sharma. Hmm, 30 dear, 30. 30.
My lord, in this for 4 expired, my lord. So we have filed an application for substitution of the legal heirs, my lord.
He is what? He was the son or the father?
Yes,
He was the father.
father expired, my lord.
When did he expire?
1/8,
Huh?
1/8/2018, my lord.
18.
Yes.
What were you doing for such stuff?
Oh, my lord, we have implemented newly, my lord. We have been implemented newly.
Forget it. We are not interested.
My lord, what happened?
Who are you?
I am one of the employee of the ATC.
No, you are for the respondent.
Yeah, no, I am for the petition, one of the petitioners. There are other 2 petitioners also.
How can there be the
Well,
3, 4, 5 advocates for the petitioner? You are for the petitioner.
Yes, my.
Vodafone Spacetel.
My lord.
Vodafone Spacetel.
Vodafone, Vodafone had been merged with us, my lord. This
What is it? ATC?
Yes.
Oh, you are for ATC?
Yes, my.
Okay, fine.
Record possibly, my lord.
The payment is claimed by the father or by the son?
Yes, my. By the father, my lord.
Why?
But
The son was also working there.
son has, and wife has, like,
Registry to list this matter again on. Full stop. It is submitted by the learned counsel for the petitioner that during the pendency of the present proceeding, respondent number 4 has passed on, comma. Accordingly, he submits that he would file an interlocutory application for impleading the heirs of the respondent number 4. Prayer accepted. The matter being of 2014. When were you engaged in this matters?
Sir, my lord, your lordship may kindly have in order 25/2025, my lord, passed by this honorable court and IAS.
Sure. 14. The interlocutory application be filed on or before 3/9/2025. Registry to list this matter on 5/9/2025. No further time will be given.
Oh, my lord, what happened in the substitution application number 2615 of 20?
It is here.
No, it is not there, my lord.
You have already filed.
Yes, yes, my lord, we have
Oh,
filed.
Tata. Registry to list this matter again on 2/9/2025 along with I number
15 of
2615 of
2025.
25 filing number,
No, my lord. Yes.
registered number. Wait. Next.
Please, your lord.
Yes.
In this case, a tender for outsourcing of the arm down.
So they say that is hit by the bilateral agreement.
31H and 31H. Your lordship, this matter is being covered judgment of the Honorable Supreme Court and
What is it?
it is your lordship. The case is from the state of Bihar and here is lordship para 5.
Same bilateral agreement. Where is this clauses here? Where do I get 31H and M?
Yes, sir. Your lordship, first, the award has been started from page number 66.
No. There is this clauses. The clauses that you are relying 31H and 31M.
Yes, sir.
Where do I get that?
Lordship, the award,
It is quoted.
yes, sir.
Where?
Para 3. The case of the union in nutshell is that on 2nd June 2005, the 8th bipartite settlement was signed between Indian Bank Association, half of the Employers Bank and the Bank Employees Federation of India, along with the other 4 union on behalf of the workmen.
And the second one, second one? 31M.
Clause 31H, while it was.
This is H I have read. Where is M?
M is also here. The last.
Okay, you give me the copies of 31H and 31M. Separate. But Mr. M. Sharma, learned counsel for the petitioner, raised to list this matter again on Thursday, did you? Thursday, subway by slip query. Thursday. As a partner matter. Done.
Your Lordship, I have the bipartite settlement.
Give me on that day. 31H and 31M.
Yes.
That will- Judgment does it, habituated.
Policy was announced in,
What is the error here?
some C forms were did not get a chance to correct them. That is whatever my exemption limit was there under the policy, whatever amount was there in the exemption, that amount would suffice my liability and of tax. That's why I'm agreed. Otherwise also I'm covered under the policy. I'm an exempted unit. My eligibility certificate is there, Lordship.
Yes, Mr. Chaudhary.
Yep,
This aspect was not brought. But they are an exempted industry
yes, but they have to fulfill the requirement to get that
benefit.
There in my name. Authorization from the sales tax department is also issued. Both are there. That there is no question.
What happened after the order? You have paid the amount.
That amount is pending, Lordship.
There was no interim direction from this court.
They have paid, that amount has been adjusted because I went to appeal, I went to revision. Got adjusted with the
Registry, due to paucity of time, the matter could not be taken up today. The registry to list this matter again after the matter in the month of October on a date to be fixed by the same order. Here, what is the issue? Ms. Gop, what is the issue here?
in this case, Lordship, I have paid the taxes and interest in 2017. But after that also they issued me demand come show cause notice and they want to impose penalty on me, Lordship. I agree with that. Lordship will find at page 82, Lordship. I have already made the payment. They have accepted this. And they have accepted the same in their affidavit also that I have made the tax and interest payment.
Yes, Mr.
Penalty here.
Hmm. 11.3. Yeah, you have an interim order here. You have an interim order. Matter, same paucity of time. Interim order passed earlier to continue until further. Until further orders. registering to list this matter again for hearing in the month of October 2025 on a date to be fixed by. Hello? Date দি দিয়া দাদা। দিবা। 10 মানত দি দিয়া তেতিয়া মই 3টা দিন পাই যাম না। এগতে এটা 3টা দিন পাই যাম। M. Sharma, Crystal.